Good morning, everyone. Let's see, I believe we are ready for the next witness.
SC calls Alan Rooks to the stand. I'm sorry, Dominion Energy South Carolina calls Alan Rooks to the stand.
I was going to let you correct that. I didn't.
Mr. Rooks, when you're ready. Do you solemnly affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth? Thank you.
Alan W. Rooks. I'm employed by Dominion Energy, South Carolina, as Manager of Electric Pricing and Rate Administration.
And have you prepared or caused to be prepared under your supervision direct testimony of 12 pages that was previously filed with the Commission in this docket?
I have.
And do you have any changes or additions to your pre-filed direct testimony?
I do.
Could you please share those with us?
Okay. I have 5 changes, and they're all related to Mr. Cassis sponsoring the testimony of Mr. Folsom. So if we could turn to page 6 of the testimony, line 2, John Folsom should be replaced with Daniel Cassis. Same page 6 of the direct testimony, line 16, that should be witness Cassis instead of witness Folsom. If we turn to the next page, page 7, line 2, that Folsom will be replaced with Cassis as well. Page 8, line 12, that Folsom would be replaced with Cassis. And then finally, on page 11 of 12, line 13, that Folsom will be replaced with Cassis as well. And that's it.
Thank you. And subject to those corrections, if I ask you the same questions here today, would your answers be the same?
They would.
Mr. Chairman, at this time, I'll move that the pre-filed direct testimony of Alan Rooks, as amended here this morning, be read into the record as if given orally from the stand.
Mr. Rooks' pre-filed direct testimony as amended this morning will be entered into the record as though given orally from the stand.
And Mr. Rooks, did you prepare or cause to be prepared under your supervision 7 exhibits labeled as amended exhibit number AWR1 through AWR7 that were previously filed with the Commission on September 20th, 2019 in response to the, or along with the amended testimony of Mr. Folsom that was adopted by Mr. Cassis and the amended testimony of Mr. Neely?
I did.
And those were filed as attachments to your pre-filed direct testimony?
Correct.
And do you have any changes to your amended exhibits?
I do not.
Mr. Chairman, I would also move into the record as the next hearing exhibit the amended exhibits attached to Mr. Rooks' direct testimony and labeled as amended exhibit numbers AWR1 through AWR7.
Okay, Mr. Rooks' amended exhibits attached to his direct testimony AWR1 through AWR7 will be entered as hearing exhibit number 7.
Thank you, Mr. Chairman. Mr. Rooks, have you prepared a summary of your direct testimony?
I have.
Would you please share that with us?
Sure. Good morning, Chairman Randall and members of the Commission. In my direct testimony, I provide and sponsor 7 exhibits and discuss the company's proposal for carrying out the avoided cost true-up contemplated by Commission Order Number 2019-43-H. Regarding exhibits AWR1 and AWR2, as set forth in the direct testimony of company witness and as set forth in the direct testimony of company witness James Neely, the company is proposing to update rate PR1 to reflect its current avoided costs. As discussed by company witness Neely, the company's rate PR1 sets forth separate avoided energy and capacity costs for both solar and non-solar qualifying small power producers. In regard to Exhibits AWR 3 and AWR 4, the direct testimony of Company Witness Neely enumerates the current component values for the distributed energy resources net energy metering methodology. AWR 3 shows the company's current NEM rider with changes redlined. Exhibit number AWR 4 is the updated version of the NEM rider that the company submits for approval in this docket. For exhibit number AWR 5, Company Witness Neely discusses the company's proposed avoided cost methodology and provides testimony regarding the various components and inputs into the methodology. This base methodology has been reviewed and approved by the Commission for many years, and the company believes that this methodology is appropriate for continued use. AWR 5 is the rate schedule setting forth this proposed methodology. Exhibit number AWR 6 is the company's proposed form contract for the standard offer as defined in Act number 62. This standard offer contract is the PPA for small power producers up to 2 megawatts in size. The standard offer PPA is designed to include the avoided cost rates proposed by the company in this proceeding for purchases of energy and capacity by the company from these facilities. Exhibit number AWR 7 is the company's proposed form contract PPA for qualifying power production facilities that have a facility rating greater than 2 megawatts and therefore are not eligible for PR standard offer rates. The form PPA does not include a price or establish a duration for the term of the agreement for the applicable QF, as these provisions will be negotiated with the QFs. In regard to the company's PR2 rate schedule and with the enactment of Act number 62 and the requirement for a form PPA, there is no longer a need for a standard rate schedule setting forth the avoided costs for QFs greater than 100 kW and up to 80 megawatts in size. Therefore, the company respectfully requests that the Commission approve the withdrawal and termination of rate PR2 effective as of the last billing cycle of April 2019. In order number 2019-43-H, the Commission determined that issues pertaining to avoided costs, variable integration costs, and updates to the values included in the NEM methodology should be bifurcated from the company's fuel cost proceeding held in April 2019. The Commission held these issues in abeyance and ordered that once these values were established, there would be a true-up of these amounts. Based upon the Commission's ruling on the company's updated avoided costs and NEM methodology in this proceeding, the company proposes to calculate the difference between those costs and their updated values and then separately account for them as an incremental cost adjustment. The company would further propose to adjust its fuel costs as part of its 2020-2-E annual fuel cost review proceeding to account for these incremental costs. By adjusting the company's fuel costs in this manner, customers will not experience any immediate rate impact, and these amounts will be appropriately accounted for and trued up as contemplated by the Commission in order number 2019-43-H. As to variable integration costs, the company proposes to true up these costs for the period from the first billing cycle in May 2019 until the first billing cycle for the month after the Commission issues its order in this proceeding. The company proposes to deduct these trued-up costs from future payments made to the solar producers with existing PPAs containing the agreement to reimburse the company for any such variable integration costs. As a result, base fuel purchase power expense will be reduced for the company's electric customers. The company respectfully requests that the Commission approve the company's requests in this proceeding and the exhibits attached to my testimony. This concludes the summary of my direct testimony.
Thank you, Mr. Rooks. Mr. Rooks, have you prepared or caused to be prepared under your supervision rebuttal testimony of 3 pages that was previously filed with the Commission in this docket?
I have.
And do you have any changes or additions to your pre-filed rebuttal testimony?
I do not.
And if I ask you the same questions here today, would your answers be the same?
They would.
Mr. Chairman, at this time, I'll move that the pre-filed rebuttal testimony of Mr. Alan Rooks be read into the record as if given orally from the stand.
Mr. Rooks' pre-filed rebuttal testimony will be entered into the record as though given orally from the stand.
And Mr. Rooks, have you prepared or caused to be prepared under your supervision 2 exhibits labeled as exhibit number AWR 6 and AWR 7 that were previously filed with the Commission as attachments to your pre-filed rebuttal testimony in this docket?
I have.
Do you have any changes or additions to your exhibits?
I do not.
Mr. Chairman, I would also move into the record as the next hearing exhibit the exhibits attached to Mr. Rooks' rebuttal testimony and labeled as exhibit numbers AWR 6 and AWR 7.
Okay, Mr. Rooks' rebuttal exhibits AWR 6 and AWR 7 will be entered as exhibit number 8.
Thank you, Mr. Chairman. Mr. Rooks, have you prepared a summary of your rebuttal testimony?
I have.
Would you please share that with us at this time?
The purpose of my rebuttal testimony is to discuss an issue raised in the direct testimony of Mr. Robert A. Lawyer, filed on behalf of ORS, and to submit revised exhibit numbers AWR 6 and AWR 7 to reflect the changes set forth in the rebuttal testimony of company witness Cassis. Mr. Lawyer recommends that the rate PR avoided cost methodology be amended by adding language that would require any updates to the factors or analysis related to the avoided cost methodology be approved by the Commission before being changed. The company agrees that any changes to the methodology itself would require Commission approval. The company presumes that Mr. Lawyer's reference to factors or analysis is not intended to require the company to seek Commission approval prior to updating data inputs incorporated into the methodology and used to calculate the company's avoided cost. Assuming the company's interpretation of ORS's proposed language is correct, the company is not opposed to Mr. Lawyer's suggestion. If our interpretation is not correct, the company believes that the language proposed by Mr. Lawyer is unnecessary, would add undue burden on the company and QFs that is not contemplated by Act Number 62, and therefore should not be approved. Additionally, my pre-filed exhibit numbers AWR 6 and AWR 7 have been revised to reflect the changes set forth in the rebuttal testimony of company witness Cassis. Since the filing of my rebuttal testimony, ORS witness Mr. Lawyer has proposed updated language in his surrebuttal testimony intended to clarify ORS's recommendations with respect to the rate PR avoided cost methodology. The company supports the recommendations as clarified and would request that the Commission approve the updated language. This concludes a summary of my rebuttal testimony.
Thank you, Mr. Rooks. Mr. Chairman, Mr. Rooks is available for cross-examination and questioning by the Commissioners.
Thank you. Okay, cross-examination, Mr. Elliott. Mr. Adams.
No questions, sir.
Mr. Golden.
No questions.
Thank you. Mr. Holman, Ms. Bowen. ORS. I didn't have enough yesterday. I did. No. Commissioners, questions? Mr. Rooks, are you feeling kind of left out?
I don't mind, this kind of left out.
Okay. Any redirect? I don't guess we have to have redirect. We don't have any cross.
No redirect.
Sometimes things happen that I don't really know about. Okay, thank you for your testimony, and you may step down.
Thank you.
Mr. Chairman, may this witness be excused?
Yes, he may.
And this concludes the company's case.
Thank you. Okay. Okay, it looks like we're on to the South Carolina Solar Business Alliance witness panels. And Johnson Development. We've got several in here. We'll let you call them.
Thank you, Mr. Chairman. We call.
Let's make sure we get that. Are you on? I
Yes,
just
sir,
want to
I'm
make sure
on.
you're on it.
Yes, sir. Call Steve Levitas for the Solar Business Alliance and Rebecca Chilton for Johnson Development. We've got a mixed panel here. Opposing counsel does not oppose this, as per conversations with Mitch.
Okay.
We've got some summaries just of Levitas. I think we're still waiting on Chilton's to come in, so Jeremy Hodges is going to hand up the Levitas summaries. All right, Mr. Levitas, please state your name, business address for the record.
My name is Stephen Levitas. I work at 130 Robert
Hang on
Street.
1 second. We need to get you sworn in first.
Yes, sir.
okay.
Excuse me.
My fault.
Both raise your right hands. Do you solemnly affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth?
I do.
Ready to roll? All right. Mr. Levitas, again, please state your name and address for the record.
My name is Stephen Levitas. I work at 130 Robert Street in Asheville, North Carolina.
And you work for?
Pine Gate Renewables as of September 3rd of this year.
Can you briefly tell us what your responsibilities are there?
My title is Senior Vice President for Strategic Initiatives. In that capacity, I'm responsible for oversight of all the company's regulatory and government affairs activities, as well as the interface between our commercial activities and regulatory developments.
And are you the same Steve Levitas who calls direct testimony to be refiled in this proceeding on September the 23rd, 2019, consisting of 32 pages?
I am.
Are you also the same Steve Levitas who calls amended rebuttal testimony to be pre-filed in this proceeding on October the 12th, 2019, consisting of 14 pages?
I am.
Were both sets of your testimony prepared by you or under your direction?
They were, yes.
And do you have any corrections or changes to either set?
No, I do not.
And Mr. Levitas, if I now asked you the same questions that are set forth in your pre-filed direct and amended rebuttal testimony, would your answers from the stand be the same today?
Yes, they would.
Mr. Chairman, the Solar Business Alliance would ask that both the pre-filed direct testimony and the pre-filed amended rebuttal testimony of Steve Levitas be entered into the record as if given orally from the stand.
The pre-filed direct testimony of Mr. Levitas, as well as the pre-filed amended rebuttal testimony, pre-filed Mr. Levitas, will be entered into the record as though given orally from the stand.
Thank you, Mr. Chairman. Mr. Chairman, the Solar Business Alliance would also ask that Steve Levitas Exhibits 1, 2, and 3 be identified as marked.
Mr. Levitas, Exhibits 1, 2, and 3 will be entered as hearing exhibit number 9.
Thank you, sir. Mr. Levitas, have you prepared a summary of your pre-filed direct and rebuttal testimony?
I have. It's a single summary combined.
Please give it to us.
Good morning, Mr. Chairman, members of the Commission. My direct testimony summarizes my extensive experience over the past decade with PURPA, and specifically with the negotiation of PURPA power purchase agreements with utilities. In addition, I've been involved in litigation before state commissions, the Federal Energy Regulatory Commission, and the courts relating to PURPA, specifically concerning PPA terms and conditions and the formation of legally enforceable obligations, or LEOs, by QFs under PURPA. One example of particular note is that the Michigan Public Service Commission recently required major changes to DTE Electric's proposed standard offer PPA based on objections raised in my testimony to the Commission. I was also one of the principal authors of the section of Act 62 dealing with PURPA and have been heavily involved in the proposed PURPA rulemaking at FERC, which you've heard about. In my direct testimony, I identified a significant number of terms and conditions in Dominion's proposed PPAs and Notice of Commitment, or NOC form, that I believe don't strike a fair and reasonable balance between the interest of QFs on the one hand and Dominion and its ratepayers on the other. In all cases, I either propose that the problematic term be deleted, or I propose modified or substitute language to address my concerns. Following the filing of my direct testimony, Dominion witness Daniel Cassis filed rebuttal testimony in which he, on behalf of Dominion, proposed a number of changes to the company's PPAs and NOC form to address concerns that I had raised. SBA and I very much appreciate this responsiveness to our concerns. In an effort to extend this spirit of compromise and to further narrow the matters in dispute, in my surrebuttal testimony, SBA accepted Dominion's position on a number of the remaining open issues. Because there are now only a limited number of issues in dispute regarding these documents, rather than summarizing my direct testimony, I'll now summarize the most significant remaining open issues as discussed in my surrebuttal testimony. These are not all the issues in my surrebuttal, but in the interest of time, I'm just going to hit the highlights. The single biggest open issue is the amount of liquidated damages, or LDs, Dominion would require a QF to pay if the PPA is terminated without the facility having been placed in service. Dominion originally proposed LDs in the amount of $55,000 per megawatt for failure to achieve timely COD. In its revised filing, Dominion has reduced that amount to $41,000 per megawatt. While SBA appreciates this reduction, the LDs are still unreasonably high and bear no reasonable relationship to actual damages that Dominion would suffer in the event that a contracted facility fails to be placed in service. In contrast, I'm going to mention what you have in front of you in the parallel Duke proceeding, and you'll see in my summary and my testimony, I refer in numerous instances to Duke's proposed terms and conditions. In contrast, Duke initially proposed pre-COD LDs equal to 2% of the expected project revenue over the life of the PPA. And in response to my direct testimony in that proceeding, Duke recently suggested an alternative methodology under which LDs are based on an expected annual capacity payment for the first 15 megawatts of capacity and a $10,000 per megawatt payment for all capacity over 15 megawatts. That's $10,000 per megawatt in contrast to Dominion's current $41,000 figure. I believe that both these approaches result in dramatically lower LDs than those proposed by Dominion. Next, Dominion seeks to impose a guaranteed energy production value on QFs of 85% in contrast to the 70% value proposed by Duke. Given the very onerous liquidated damages imposed in the event of a shortfall, which we have not opposed, I submit that the Duke threshold is more appropriate. But to make matters worse, and this was touched on in commission questions yesterday, Dominion would be able, under their proposal, to terminate the PPA based on a limited number of shortfall events, as opposed to simply collecting LDs for shortfalls as proposed by Duke. And that termination would, in fact, serve no purpose because under PURPA, the QF would be entitled to enter into a new PPA. Third, Dominion has not proposed contractual terms for the inclusion of energy storage devices. As you know, they're required to propose a solar plus storage rate, but as things stand, developers will have no idea how to qualify for that rate. And again, in contrast, Duke has proposed an energy storage protocol in its large QF PPA and has now agreed to incorporate the same protocol in its standard offer PPA. Fourth, the Dominion PPAs don't include a limited due diligence period as included in Duke's proposed large QF PPAs and at least in some prior SCEG PPAs. In my direct testimony, I proposed a new section 3.1b to the Dominion PPAs for this purpose that was drawn almost verbatim from the Duke large QF PPAs. And this would give the QF a limited period of time with price certainty before it had an irrevocable commitment under the PPA. Next, while SBA has offered to accept, now has offered to accept Dominion's proposed measure of damages for PPA termination after the facility is placed in service, Dominion proposes a totally unreasonable 50% floor on such damages that could potentially result in a massive and unjustified windfall to the company. I explain this in detail in both my direct and rebuttal testimony. And I would also note that there is no comparable floor on Dominion's damages to the QF should they be in breach of the agreement resulting in termination. Finally, in terms of these kind of open big picture issues, I contend that PPA termination is not an appropriate remedy for failure to achieve an interim milestone where the QF can demonstrate that it will still achieve timely COD. So the ultimate milestone under these contracts is when the project is placed in service. They typically have some interim milestones to be sure the project is on track. My notion, and Duke agrees with this, is that missing an interim milestone shouldn't be grounds for termination if the project is still on track to achieve the ultimate COD milestone. And again, the language that I proposed in my direct testimony was drawn virtually verbatim from the Duke proposed large QF PPAs. I want to turn briefly to the NOC form and just mention a couple of issues, most notably the prerequisites for LEO formation. And the fundamental question that I hope you will consider on this issue of the form and LEO formation is what steps should a QF reasonably be required to take before being able to lock in pricing? That's really, that's really the key question in this inquiry. QFs need certainty at a reasonable point in the process. The question is, what is that reasonable point in the process that allows a QF to be comfortable incurring substantial development expenses? I explained in my direct testimony why it's not reasonable to require QFs to obtain all environmental permits and land use approvals without having firm pricing in place. Accomplishing those objectives can cost hundreds of thousands of dollars, and in my opinion, is not a reasonable requirement without the QF knowing what its project economics are. I also don't believe it's consistent with PURPA to require that a seller have either established interconnection service or signed a system impact study agreement as a condition of LEO formation, because this improperly places control over LEO formation in the hands of the utility. My alternative suggestion is to require that if a system impact study agreement has been tendered by Dominion to the seller, the seller must have executed that agreement and returned it in a timely fashion. And finally, with respect to the NOC form, I continue to think that the seller should have the ability to terminate a non-contractual LEO where interconnection costs exceed $75,000 per megawatt, and that's exactly what Dominion has now agreed to with respect to termination of the PPA. This concludes my summary.
Mr. Chairman, thank you, Mr. Levitas. Mr. Chairman, we can turn to Ms. Chilton if you're ready. I frankly can't remember. Has she been sworn? Yes. We good? We're good there, okay. Ms. Chilton, please state your name and business address for the record.
My name is Rebecca Chilton.
Let's get your microphone on. Punch that little button till the red light. There you go.
There you go.
My name is Rebecca Chilton. My business address is 101 Hunter Place, Carborough, North Carolina.
And for whom do you work?
I am principal of my own consulting firm called Izuba Consulting.
And briefly, can you, in 30 seconds, tell me what that's about?
I provide consulting services to lending institutions and renewable energy developers on operations, financing, and development issues.
And are you the same Rebecca Chilton who calls direct testimony to be pre-filed in this proceeding on September the 23rd, 2019, consisting of 11 pages?
Yes, I am.
And are you the same Rebecca Chilton who calls Sir Rebuttal to be filed in this proceeding on October the 11th, 2019, consisting of 5 pages?
Yes, I am.
And were both sets of your testimony prepared by you or under your direction?
They were.
And do you have any corrections or changes to either set?
No, I do not.
And Ms. Chilton, if I now asked you the same questions that are set forth in your pre-filed direct and Sir Rebuttal testimony, would your answers from the stand be the same today?
They would.
Mr. Chairman, Johnson Development would ask that pre-file direct testimony and the pre-file surrebuttal testimony of Rebecca Chilton both be entered into the record as if given orally from the stand.
Ms. Chilton's pre-filed direct testimony and pre-filed surrebuttal testimony will be read into the record as though given orally from the stand.
Thank you, Mr. Chairman. And there are no exhibits for Ms. Chilton.
Thank you.
Ms. Chilton, have you prepared a summary of your pre-filed direct and surrebuttal?
I have.
Please provide that summary to the commission now.
Yes, thank you. Good morning, Chairman Randall. Good morning, Commissioners. Thank you for including me in this proceeding today. I was asked by Johnson Development Associates to provide testimony based on my more than 21 years in structured finance, the last 9 years of which have been focused on lending to and supporting the development of renewable energy projects nationwide. Specifically, I was asked to speak to the commercial reasonableness of certain terms of PPAs between the utility and qualifying small power production facilities, or QFs, as defined in PURPA and the South Carolina Energy Freedom Act. I was further asked to address the weight both laws give to their respective goals and how those goals should be reflected in PPA contract terms considered in this proceeding. I note first in my testimony that PURPA, FERC regulations, and the Energy Freedom Act all direct the Commission to strike a balance between two important concerns. First, that the rates that South Carolina ratepayers ultimately pay for QF generation must be just and reasonable, and second, that small power producers must receive fair treatment and have the ability to obtain PPAs with terms that do not discriminate against them in South Carolina's electricity generation landscape. I would emphasize here, as I do in my written testimony, that this is a both-and analysis. This Commission must both ensure fairness to QFs and create just and reasonable outcomes for ratepayers. Because I am speaking primarily from a financing party's perspective, my testimony then delineates an implicit requirement of both PURPA and the Energy Freedom Act that QFs must be able to access regularly available market rate financing. Small power producers cannot push all costs of their projects, whatever they may be, onto ratepayers, nor do they have access to the preferential financing that the monopoly utility enjoys. They must seek financing that can be paid for within the strict confines of the PPA. And thus, to be fair and balanced towards QFs, this Commission should consider the effect that its avoided cost analysis and the other PPA terms it mandates have on the ability of QFs to secure financing. Avoided cost rates that are artificially low because they do not fully account for a utility's true generation costs and the benefits that QF purchases bring to ratepayers. Short-term PPAs and contracts that carry unnecessary extra charges are all examples of terms that impede a QF's access to regularly available market rate financing and thus are discriminatory towards QFs. With regard to the issue of PPA duration specifically, my testimony highlights that the ESC's proposal to abandon past practice and limit PPA terms to no longer than 10 years would represent a direct contradiction to the practice of other parts of the Dominion corporate family, where solar PPAs from 15 to 25 or even 30 years are common, would dramatically reduce the ability of QFs to access mainstream capital, would deprive South Carolina ratepayers of the protections against fuel price variations and uncertain future capital costs of generation that long-term PPAs bring, and would be inconsistent with the Energy Freedom Act's specific mandate to use such terms as PPA length to promote renewable energy in South Carolina. Finally, my written testimony reasons that a longer PPA contract term, accompanied by an appropriately calculated avoided cost-based purchase price, will result in a greater proportion of QFs accessing mainstream capital than would be the case under the utility's unnecessarily restrictive proposals. I conclude my testimony by recommending, respectfully, that the Commission set the tenor of PPA contracts at a minimum of 15 years, with appropriate conditions as set forth in South Carolina's Annotated Code, Section 584120, sub F1, to facilitate the opportunity of QFs to obtain financing in South Carolina. Further, to meet the high standards set by the legislature, not just to accept renewable energy in the state, but to affirmatively promote it, I recommend that this commission direct that the terms of DESC's PPAs be set between 15 and 20 years, and that some PPAs be approved for longer than 20 years, all with the aforementioned statutory conditions. DESC filed rebuttals to my testimony, to which I in turn responded in my surrebuttal testimony. To summarize the points made in that portion of my testimony, I first disagreed with certain contentions of DESC's John Raftery and restated that PURPA and Act 62 both have a specific focus on QFs, that QFs can be rightly viewed as competing with the utility in the generation space, and that the avoided cost-setting process is a nuanced, multifaceted, and, to some degree, predictive one. Second, in response to Daniel Cassis, I reiterated the both-and point made earlier, that the mandate of both PURPA and the Energy Freedom Act is to be both non-discriminatory towards QFs and to set rates for ratepayers that are just and reasonable. My surrebuttal testimony then went on to emphasize the benefits to ratepayers of longer-term PPAs, as noted earlier. Finally, my surrebuttal testimony expressly preserved the right of Johnson Development Associates as intervener to propose to the Commission for approval any decrements to avoided cost or other conditions required by Act 62 for certain PPAs of longer term, and then only when timely. And that concludes my summary.
Thank you, Ms. Chilton.
Counsel, do you have a summary of this witness's testimony
It is
available?
on the way from my office.
Thank
I wish
you.
we'd planned that a little bit better, but there was some midnight work there, so. But we'll get it to you when it gets here. Mr. Chairman, these witnesses are available for cross and for commission questions.
Thank you. Any cross-examination?
We have no questions of these witnesses.
Okay. Any other parties have cross-examination questions for these witnesses? Commissioners. Commissioner Urban.
Thank you, Mr. Chairman. Good morning. Welcome. I'd like to direct my question first to you, ma'am. Have you been involved in financing, decision-making in other jurisdictions outside of North Carolina?
Avoided cost?
Yes, ma'am.
I have been informally involved on one occasion in January of 2017. The public staff of the North Carolina Utilities Commission invited me to have an informal conversation, again, from a financing party's perspective, in response to certain proposals of the Duke Energy subsidiaries in that state. But I have not submitted formal testimony to any commission otherwise.
Are you aware of what Dominion is doing in other states as it relates to these PPAs, the terms and conditions?
Yes. I derive my information from their website as they describe the projects that they own in other states.
Is there a significant difference in what they've proposed in this docket as opposed to what they're doing in other jurisdictions?
There's a significant difference in term. In multiple other states, they are entering into PPAs for 15, 20, 25, and sometimes on a few occasions 30 years.
How long has that been going on, if you know?
I believe that it's been going on since roughly 2017.
From
not all, not all of the projects that they highlight are yet complete and operating.
Do those PPAs in other jurisdictions have liquidated damages provisions?
I have not reviewed the PPAs themselves, just the overview information provided by the utility on their website.
Why would a solar provider or contractor need a term of more than 20 years?
I think there are a number of factors that go into the cost of development, whether it be the land cost, the particular type of equipment that is required for that development, and that impacts the necessity for a greater or lesser amount of financing. And so longer terms allow the financing to be increased because the amortization payment paid, particularly on the loan side, is more favorable, and you're allowed to finance then a higher cost if you are encountering that.
When you spread the length of the term to 20 or more years, doesn't that shift some risk to the ratepayers for being kind of trapped into a PPA that would be affected by changing technology and the like?
I think that there are, as I mentioned in my summary, there's a predictive aspect, obviously, to this proceeding, and we cannot know whether, for instance, the drivers of cost to the ratepayers will go up or down. What we do know is that the PPA provides a fixed and certain price for that period of time, that it is somewhat shorter than other generation modalities where the utility is locking you in to a type of generation that is also affected by changing fuel prices and technological change. And so I think the certainty in the larger mix of the total utility generation is actually a benefit in my view, even at 20 or 25 years.
Ms. Chilton, are you familiar with the term flexible solar?
Not as such, no.
We heard yesterday from a witness for Dominion, Dr. Tanner, talking about how the next generation of solar is going to be designed so that it can account for the incremental changes during a cloudy day and give more or less power as needed to help the company meet its reserves.
Would that be including a storage
It could.
as well?
It could also include storage, and that was going to be my next question for you. Have you seen any PPAs yet that are including storage?
I have in North Carolina, in my experience, North Carolina, there were a set of QFs developed with a rural electric cooperative, not with one of the major utilities, that included a storage component that was used both to meet peak demand and to provide sort of stability for that cooperative in its generation.
And so is it fair to say that the technology is rapidly changing, and to lock in the parties to a 20 or 30-year agreement could disincentivize parties to include or prevent those parties from including the most recent technological advances? Wouldn't that be fair to say?
I'm not sure that would be entirely fair, because I think that a QF owner, because their revenue is fixed by the PPA, would be incentivized to look around to see how that particular project could be adapted over time to technological add-ons or changes that could improve efficiency. I do know that panels, for instance, could be relatively economically changed out if there were a dramatic increase in efficiency, which would enable the QF to provide more and more certain power to the utility. So I don't know that while the PPA is fixed, that the technology is exactly fixed, and there would be, in my view, an equal incentive for the QF owner to look for other ways to provide power and services to the utility.
Have you seen any PPAs that contemplate adding solar storage at a later date as the technology advances?
No, I have not.
Do you think that would be a reasonable approach?
I think that could absolutely be an option, that there could be some preliminary provisions that would delineate kind of the process for that adaptation, were it to be cost effective and were the utility to find that sort of useful as an additional source of services.
How can we incentivize the parties to do that?
I am not.
Perhaps
Yes,
I
sir.
can.
Yes, sir.
Commissioner Everett, there are a couple of ways, and it certainly is an opportunity that's very much in future, in the near future. And so the first thing is to be sure that the PPA itself readily allows for the addition of storage without penalizing the QF or undoing the terms of the PPA. And I don't read the Dominion PPA to prevent those additions, as I recall. When we get to this next week, I think you'll see some problems with the way Duke is approaching this issue. So you have the PPA side. We want to be sure that the PPA allows the additions and provides the protocols, which I mentioned, which are lacking from the Dominion PPA.
What protocols are missing from the Dominion?
Well, if I could refer you to Duke's proposed PPAs, they have an exhibit or attachment that is a page-and-a-half document with detailed operational protocols as to how storage has to be operated in order to be added to a facility or be included in a facility. And I think they're relatively non-controversial, but for whatever reason, they haven't been included in the Dominion PPA. And then the other side, which we've dealt with at great length in North Carolina, is the interconnection side of the equation. So there are technical issues that have to be dealt with to be sure that the studies that have been done on the interconnection side accommodate the change in the profile that would result from the addition of storage. Again, those should be relatively straightforward, and the key is to have an interconnection procedure that readily allows the quick addition, a sort of expedited process, as the North Carolina Commission has called for those storage additions to be made without taking years of additional study.
And what's been the company's response to why those were not attached to the PPA or provided as a part of, incorporated in the PPA?
I believe that it's the case. I raised the issue in my direct testimony, and while Mr. Cassis was fairly thorough in responding to my comments in his rebuttal testimony, for whatever reason, that issue of the lack of storage protocols was not addressed in his rebuttal, so remains a question mark. But perhaps it's something that we could resolve between now and when you need to make a decision on this.
Well, I would encourage the parties to try and do that. It makes sense. And if this is going to be a win-win-win situation for everyone, we've got to anticipate that this solar storage technology is going to be here sooner than later.
That's right.
And so I would strongly encourage you to press on that issue.
I think it then supports the idea of having a longer-term PPA, which allows for that adaptability and the improvement of services by the QF over time.
Well, it could. That's fair to say it could, but I think we'd have to look at the technical aspects and so forth. But thank you both for your testimony today.
Thank you.
Thank you, Commissioner Whitfield.
Thank you, Mr. Chairman. Thank you both for being here. It's important that we hear from you, just like it's important that we hear from all the parties involved in this case, and we certainly value your input. I've just got a few questions, mostly for you, Mr. Levitas, but I'd like to lay a little bit of groundwork before I ask them. We're kind of in uncharted waters here. Act 236 in 2014 started this process, and now with Act 62, the Commission often is asked to rule on things that affect the future, of course, all the time, and this is certainly no different. And Mr. Levitas, I want to ask you a couple of questions that might give us a little window into that. Mr. Levitas, and I'll give you a minute to get there, you describe how avoided cost rates may change over a period of time on page 8 of your direct testimony. You point out that long-term PURPA contracts should balance over time, and of course you've cited your long work with the PURPA Act of 1978 in your background, but specifically on page 8 of your testimony, lines 6 through 8, you say, FERC has recognized this potential for avoided cost rates to move in either direction over time, and thus for the impact of long-term PURPA contracts on ratepayers to balance out over time. And relative to that, my questions are, in your opinion, and again, you've cited your long background in this, in your opinion, are small power producers suited to withstand a fixed revenue stream while the cost to provide the energy fluctuates. And I know Ms. Chilton had just had the exchange with Commissioner Irvin about fixed revenue streams. So could you address that?
Well, I'm not sure I totally understand the question when you refer to costs fluctuating. So to be clear, the costs of the individual developer with respect to a particular project solar project don't fluctuate a great deal over time because they largely consist of the capital costs that the developer incurs at the time that it builds the project. Now, it's true that the cost for other developers over time could go up or down as equipment costs, construction costs, land costs may fluctuate, but with respect to any particular project, those costs are essentially fixed, which is why it's so important to have fixed contracted revenues at the time that the contract is executed. I thought the question you were going to ask me about is, if I may, is one that was raised yesterday, which is it is the case that in its recent notice of proposed rulemaking, the FERC talked about the fact that what's happened in recent years is that those costs have mostly come down, not fluctuated so much. And I wouldn't disagree with that, but I would make the point that where costs are today is extremely low. And so there is not much reason to think that those costs going forward, and by that I mean the avoided costs, are going to do much other than go up, given where gas prices are today and how low those prices are. So while it's true that in hindsight, that sort of fluctuation and balancing that FERC anticipated some years ago when it made that statement hasn't proven to be true in recent years, I think there's every reason to believe that locking in rates now at these very low rates is going to be extremely good for ratepayers over a long period of time. And so I'm sorry if I'm not sure.
No, you certainly were certainly fair to go there, and I guess to kind of follow up on that, with what Ms. Chilton said about the, having a fixed revenue stream to obtain financing, and then should these costs change, we don't have that crystal ball, and should that, and also if you could maybe address a little bit more, I know she did, where Commissioner Irvin was going, should technology change and that technology allow for storage, could you address some of that as well?
Sure. Well, I think the important thing is that at any moment in time that a utility is bringing new resources online, you want to try to be sure that you get a fair and reasonable rate, and ideally the best rate that is available for ratepayers. But if things are going to be built now, you have to deal with the inevitable or the unavoidable uncertainty as to what the future is going to hold in store. If you think about buying a personal computer, you can't say, well, I'm never going to buy one because the prices keep coming down. At some point, you need a computer, you buy one at the best price that's available, and you don't say 2 years from now, oh, I made a bad deal because the prices are cheaper now. The key thing, and this is true with every major investment that Dominion or any utility has made, that to build large infrastructure projects that cost tens of millions of dollars, the parties have to have certainty as to the revenues that the financing parties have to have certainty as to the revenues that they will receive over time. That's why the utilities don't build anything unless they know that they have will have cost recovery. And of particular note, all of the I think virtually all of the investor-owned utilities have non-regulated businesses in which they do exactly what we do. They build plants under contracts with other parties. And if you look at the contract lengths that those utilities require, I'm not familiar with the Dominion numbers, but I suspect that they're pretty close. But I think we presented to you in ex parte proceedings with respect to Duke's non-regulated business, where the average contract length, we researched that and provided that information, I believe is 17.5 years for the Duke non-regulated business. And I'm not sure that Duke non-regulated has ever entered into a PPA of less than 15 years.
Mr. Levinas, lastly, I guess in your expert opinion, with your background with the PURPA Act of 1978, QF, small power producers, how have they, could you share some examples that you might be familiar with how they've operated in other areas, in other states, and other jurisdictions, and how they've maybe successfully addressed some of these issues in other areas.
Well, I think the most significant thing to say about other areas in the country is that there have been relatively few states in the country that have implemented PURPA in what I would say in a lawful way, a reasonable way, in a way that serves the Act's purpose of encouraging QF development. So there are just not that many states in the country that have actually seen any QF development because they haven't done what Act 62 requires, which is to direct their commission to implement the law in a fair and balanced way. So you simply have very little QF development. I mentioned Michigan. There's been a good bit of activity around QF development in Michigan recently. Washington State just adopted a new set of rules with 15-year PPAs for QFs. There have been a couple of states where, like Idaho, where QF development started to take off and the commission came in and shut it down with very unreasonable short-term, I believe, 2-year PPAs. Never been another QF developed after they did that. Unfortunately, we don't have a lot of examples to go by. Of course, the great example of QF success is North Carolina, where we've led the country through a set of, I would say, enlightened PURPA policies. And when we got to a point where there had been a tremendous amount of QF development in North Carolina, we worked with the utilities to look at alternative models to recognize the amount of penetration that occurred in the changing circumstances.
I was going to say our neighboring state to the north was one of the early high penetration levels of solar generation in the southeast.
That's right. And we've had, I've lost track of the number, but I believe the economic value of the investment of solar in North Carolina is well north of, I think it's approaching $10 billion of economic activity as a result of that.
Well, thank you for your testimony, both of you, and certainly thank you for being here. And, Mr. Chairman, that's all I have.
Thank you. Commissioner Hamilton.
Thank you, Mr. Chairman. Ms. Chilton, I have a question for you. Mr. Levinas touched on this, but on page 7 and 8 of your direct testimony, you discussed the volatility of natural gas prices to illustrate how a longer-term fixed QF PPA contract protects ratepayers. Could you elaborate on this for us?
Yes, and I think Steve made a good point that in the recent years, there's been a dramatic increase in the production of natural gas in this country, and so prices have fallen. However, in looking at the larger scope of the volatility of gas prices from 2002, when the Energy Information Administration began to track natural gas prices as used in electric generation, they have risen from $2 to $12 and fallen. And now also we are looking at multiple, and I think if you are looking at this single factor, among others, in determining avoided cost, you're looking at a future in which natural gas production is unpredictable. The use of exports to provide demand or to increase demand for natural gas from the United States will grow and is growing. A lot of infrastructure has been put in place to export natural gas. That will affect prices. And so looking at this single factor, which I would strongly emphasize is among many, that it is very possible, and the Energy Information Administration predicts that gas prices will rise significantly over the next 30 years, and certainly even within a 15-year span of a proposed PPA, that gas prices could increase significantly, and that would create a circumstance in which more of this balancing and evening out would certainly happen, and that long-term PPAs entered into with QFs at currently relatively low avoided costs would protect the ratepayers of South Carolina by giving them the benefit of a locked-in low price.
Thank you, ma'am. Could you tell me, in your opinion, what the shortest PPA period that would be beneficial both to the QF and to the ratepayer?
It is my opinion, and definitely stated with the intervener Johnson, that a 15-year PPA is typically, if there is a fair and balanced and full avoided cost analysis, they don't act independently, but that typically a 15-year PPA minimum is one in which a number of QFs would be able to reach completion and to contribute to the electricity needs of South Carolina.
Thank you, ma'am. Thank you both for your testimony.
May I add one thing in response to that question? I think both Ms. Chilton and I in our testimony pointed out the fact that PPA length cannot be evaluated in a vacuum because it's entirely a function of price. So you've got price and length because those two factors together determine the revenues that the developer will receive and in turn the revenues that its financing party can rely on. So we see a lot of talk, not just here but elsewhere, about the PPA length in a vacuum, and it really is a function of price. And of course, you have in front of you a proposal in this proceeding to push prices further down. I would suggest every time you push prices down, PPA length needs to go up.
Thank you very much for that, sir. Thank you, Mr. Chairman.
Thank you. Commissioner Williams.
Thank you, Mr. Chairman. Good morning. I really appreciate you all being here today. I want to have a little bit of a conversation with you, just to get a better understanding of what our ratepayers should expect, depending on whatever may happen in the future. So, as I understand it, your position is that a longer-term PPA is appropriate to protect ratepayers because the price of gas, according to the studies that you cited, is supposed to go up. Is that correct?
That's one of the factors that would protect ratepayers. I think another one is the uncertainty of the cost of other generation types, and the fact that the full cost of those, even if there are cost overruns or abandoned costs, will be pushed down onto the South Carolina ratepayers. Whereas with a QF, you have a PPA, and the costs are already fixed, they are known, they do not change, and so there's a protection for the ratepayers in that sense as well.
Gotcha. That all makes sense to me. But this is a question that is just in the back of my mind. What happens if those studies are wrong and the price of gas continues to go down? Say you get really low. I don't know what the lowest has been in the last 10 years, but let's just say 10 years from now, we sign a 20-year deal. 10 years from now, the price of gas is at historic lows never seen before. And ratepayers found out about that, and they're wondering, well, why are we in this 20-year PPA? Gas rates are at historic lows. I mean, there's not an option to refinance. How would I explain that to a ratepayer?
I think what you would have to look at is what were the competing choices at the time. I think you look at every moment in the past as there have been choices of generation by the utility and the costs associated with that. And sometimes, and often, their choices for generation math out to be roughly what they had predicted, but there are significant instances where the math that they predicted is not correct, and the ratepayers have had to bear that burden.
We've been through that before.
Yeah. I think that natural gas prices are one of only multiple factors that affect ratepayers, and that's a combined impact. And so while it is possible that natural gas prices could fall further, I don't believe that they will. I don't think any of the rational analysis would support that. But I understand your point. I think the answer is that we make the best possible decision for the citizens of South Carolina, given what we know at the time, the best possible data, the most objective data, and that we are delivering them clean energy, and that is, and at the time, then also you are also creating new generation as needs change and increase that can take advantage of those pricings. So I think That would be my response. I don't know if Steve has more to
Well,
add.
I would just add, I think that's well stated, that you face the countervailing risk that you're going to be standing in front of ratepayers in 20 years and having them say, what were you thinking? You had a chance to lock in long-term energy supply at these low rates and you didn't do it, and now we're paying 2 or 3 times as much. And so you've got a risk on both sides and have to make a judgment as to which of those scenarios do you think is more likely given the current state of play with respect to gas prices and other considerations. And I would just also say that apart from the price itself, thinking about the other risks to ratepayers, and Ms. Chilton touched on this, but what QFs and independent power producers offer you and ratepayers is zero risk with respect to cost overruns, with respect to delays, with respect to the future performance of these facilities. All of that ratepayers are insulated from. And I would submit to you that with the generation market being what it is, it should never happen again that South Carolina ratepayers are subjected to the possibility of being made to bear cost overruns or the cost of facilities that are never placed in service.
Thank you for that. I appreciate you all indulging me. I have some folks in District 6 who are very interested in those answers that you provided. Some more specific questions. And sir, your name is Mr. Levitas?
Levitas.
Levitas, okay. Levitas. Mr. Levitas.
No N. I know there's some Levitises here in South
Right,
Carolina.
I thought that's what I was hearing, and I didn't. Okay, all right, Levitas. All right, sir. With respect to the failure to achieve timely commercial operations in your rebuttal testimony, page 5, lines 2 through 3, you argue that actual damages are largely administrative, and you propose that liquidated damages of $5,000 per megawatt AC for the first 20 megawatts and $2,000 per megawatt AC thereafter. You note that this is based on your negotiations with Consumers Energy in Michigan. Could you provide more specifics regarding this PPA with Consumers Energy? Specifically, were the energy rates in this PPA based on avoided costs?
Yes, they were. And so the Michigan Public Service Commission over the last several years has conducted proceedings much like this one to establish avoided cost rates, PPA standard terms and conditions. And I've been involved in those proceedings both for Consumers Energy and DTE Electric. In the case of Consumers, we were able to negotiate much of the disputed terms. There were just a couple of issues that the commission had to resolve, but the 5,000 megawatt LDs was one of those terms that we agreed to. In the case of DTE, we were not able to negotiate any resolution, so my testimony there, as I mentioned, recommended that DTE be treated the same way as Consumers, and just in the last couple of weeks, the commission issued that order agreeing with me and using the $5,000 figure for DTE as well. So I'm not sure if I've answered your question, but I'm happy to explain more about my position with respect to the LDs. I heard Mr. Cassis's testimony yesterday. I still don't understand the basis for the very large number, the $41,000 per megawatt, because if a QF is proposed and is entered into a contract and for whatever reason fails to come online and place in service, it's hard to see how Dominion and its ratepayers actually suffer any damages at all. You've heard a lot of testimony from them that they would really prefer that these facilities not be built. They're in various ways proposing measures that would discourage QF development. We haven't seen any recent PPAs. And so if, in fact, they don't believe that these PPAs are good for ratepayers and one of them goes away, it's hard to see that they're suffering a lot of damages, and certainly not on the order of millions of dollars per project.
On what basis were these liquidated damages established? Were there negotiations between the parties or analysis performed by Consumers Energy?
No, I don't believe there was any detailed analysis. Again, there was negotiations. There were, with respect to consumers, we had extensive negotiations on every point in the PPA over a period of months that eventually led to a consensus proposal that we presented to the commission. And I think the number, which admittedly is, it's not a huge number, although it's, I mentioned earlier, Duke is proposing just a little bit north of $10,000 per megawatt in its revised proposal. But I think it largely reflects the recognition that there are not a lot of actual damages in this case. And keep in mind that Dominion is not proposing to pay QS for capacity, so it's not losing the benefit of some capacity that it was relying on. It simply has to go utilize its other resources or go into the market and replace non-renewable energy because they're not actually receiving the renewable attributes of these facilities. And we acknowledge there's some administrative cost to do that, and that's largely, as I've said in my testimony, what informs the value that we proposed.
You also mentioned that Dominion should not be entitled to both extension payments and liquidated damages. Is that the industry standard?
Not in my experience. A large portion of my experience, of course, is with Duke, and Duke has always had in its negotiated PPAs meaningful liquidated damages, as they now propose in their parallel proceeding. And in the past and in the current proceeding, their delay damages and liquidated damages in the event that you simply never get in service are rolled together. So they're not additive. They're all part of a single value or single number.
With respect to guaranteed energy production, in your surrebuttal testimony, page 6, lines 4 through 7, you refer to Duke's 70% guaranteed production value and state that 70% be adopted by Dominion as well. Based on your experience and time in the industry, can you characterize the underlying annual variability of solar output given variability in weather conditions?
Well, I will tell you that if a solar facility is performing under 90% or even perhaps under 95%, it's experiencing a lot of trouble beyond its exposure to these LDs. I mean, we're seeking to hit numbers that are 95% and above. And I have to say, from my experience, these guaranteed minimum numbers are kind of all over the lot, ranging from the 70% that I mentioned. Some, I might have seen one as high as 90. I wouldn't swear to that, but I've certainly seen 85 before. I don't think that there is a right answer necessarily. This is not perhaps the most important point in that we have a disagreement with Dominion on. But 2 points. One is you've got 2 investor-owned utilities that are fairly similarly situated here in the state, and I'm not sure that there's a lot of basis for having a 70% threshold for one utility and an 85% for the other, so trying to reconcile those two, maybe you split the difference. The second thing with respect to the shortfalls mentioned in my testimony is that Dominion, unlike Duke, and I believe you may have asked a question about this yesterday, would propose that if there are, I believe it's 2 consecutive years with shortfalls, that they could then terminate the PPA as opposed to just continuing to collect the damages. And I mentioned that in my summary. That's a very harsh remedy and very problematic with respect to financing parties to have a termination remedy like that. And I would submit that it's going to be the unusual situation where that occurs. QFs have huge incentives already to perform at the maximum level possible. And if a QF is experiencing that kind of problem, it's going to work diligently to fix it. And to have a situation where the utility could terminate and force the QF to then enter into a new PPA would be very problematic for financing, and I think is unreasonable.
With respect to termination post-commercial operation, your surrebuttal testimony on pages 8 and 9 describe modifications to Dominion's proposed formula that would be acceptable to SBA. Are you recommending removal of a price floor altogether? If so, could you tell us why?
Yeah, the price floor that Dominion has proposed is very unusual, I mean, unprecedented in my experience, and I mean, if I had to say, maybe the single most unreasonable thing in the whole document. And let me just take a minute to explain how it would work. It's in my testimony, but you might not have had a chance to look at it. So the way these measures of damages typically work, let's say that the QF had a PPA price that was levelized at $32. Its facility turns out to have been badly built, or it's wiped out by a hurricane, and they don't rebuild it, it's gone. And so now under this measure of damages, they would be liable to the utility. The utility is going to go into the market and seek to replace the lost energy. And the measure of damages is the difference between the contract price that they had negotiated and the new price that they get. This is classic contract cover damages that we're all us lawyers are familiar with. So if the contract price was $32 and now it turns out they have to pay $34, their damages are $2 per megawatt hour for the production over the remaining life of the contract. What this floor concept does is to say, we don't care what the actual damages are, we're going to make that QF pay damages equal to half of its purchase price or its contract price. So now instead of paying that delta of $2 per megawatt hour, the QF, the defaulting QF, would be paying $16 per megawatt hour, even though Dominion's actual damages were only $2 per megawatt hour. And that's obviously a huge windfall to the company. I've never seen anything like that. And I would also point out that there is a reciprocal provision if somehow Dominion would go away or decide not to honor its obligations under the contract. You have the same situation in the reverse. The seller goes out and sells it, attempts to sell its power to someone else, and its damages against Dominion would be, again, that delta. It had a price for $32, it's only able to sell it for $30, so it gets $2 in damages. There's nothing in the provision that says there's a floor in the other way, that the seller would automatically get $16 in damages, even though its actual damages were $2.
Why do you think they would make such a proposal? Have you seen anything like that before?
I never have, and I'm mystified by it.
All right. Last question for me. In your cerebuttal testimony, you say that SBA is now prepared to accept Dominion's proposed requirement that the seller commence delivery within 365 days of its notice of commitment to sell, provided that such obligation is subject to the same excusable delays as in the service deadline under Dominion's proposed PPAs. This is page 12, lines 18 through 20. In the case that there are no excusable delays and construction takes longer than 365 days, wouldn't the seller find itself being terminated? Or in other words, do you think that 365 days is sufficient for particularly large QFs?
I think the answer to that is yes, which is why I took that position in the testimony. I mean, typically even large facilities can be built in 6 months or so, I think is probably fairly typical. Now, I think that the QF also has the option, and I think Mr. Cassis may have pointed this out, if the QF simply goes straight to PPA execution, I don't think that provision applies, but I'd have to check the provision. But I think that's probably okay. I guess I want to reserve the right to take a closer look at that. But the key point that I was making is that, and I believe that Dominion has now corrected this, is to make sure that the QF seller is not exposed to the interconnection delays or time frame of the utility, because that's not within our control.
Thank you, sir. Thank you, ma'am.
Thank you. I know we have some more commissioner questions, but when you have a cold, everybody says, drink a lot of fluids. And I have. And so we're coming back in 10 minutes. Please be seated. Okay, welcome back. I believe we've got, see, Commissioner Belser. Got your mic on.
Morning.
Good morning.
Ms. Chilton, in response to a question, I believe from Commissioner Hamilton, you used a phrase, upon completion. Tell me what you mean by that. When you were talking about the PPA, is that just when it runs the length of it, or you were talking about financing?
The financing typically, I think what I might have meant, and I'm not entirely remembering the phrase, was that the typical long-term financing will start its meter, if you will, at completion of the facility at its commercial operations date, and so the financing term and the PPA term are interrelated because that level of certainty of 15, 20-year PPA is coincident with the term of the permanent financing. There's typically a different or separate financing during the construction phase.
Okay, and then the regular financing for the term of the contract.
For the term of the contract and even further. So a financing party may decide to take the risk on the subsequent PPA and its avoided cost rate and extend the term beyond the initial contract length. But the longer that contract length, the more financing is going to take that tail risk, that extended risk, or that you simply have a longer term. If a financing party is only going as long as the contract, you have the ability to finance your costs more effectively, but always, as Mr. Levitas indicated, in conjunction and in reference to what the avoided cost is.
Thank you very much.
Thank you.
Mr. Levitas, I've had some questions about, and you've already addressed some of them, so I'm trying not to repeat, but I do want to go back to liquidated damages, if we could, and I believe in response to questions from Commissioner Williams, and in your testimony, you indicated that your proposal of $5,000 per megawatt, that was based out of the Michigan, and what you did with the consumers?
Consumers, and now what the Michigan Commission has ordered DTE Electric to do as well.
Well, are there any other factors that your $5,000 per megawatt and $2,000 above 20 megawatts are there any other factors or norms that recommendation is based upon?
No, as I said, it was the product of negotiations of just trying to find a reasonable number, recognizing that in our judgment, the utility doesn't really face a lot of potential actual damages in that situation, and that largely what's being accounted for is the administrative cost of having to address the loss of the planned capacity or the planned resource in some fashion. I shouldn't say capacity, since the capacity is not being relied on in this proposal. I will say that in the interest of full disclosure, I recently filed rebuttal testimony in the Duke proceeding, and I mentioned in my rebuttal testimony here and in my summary that Duke has proposed a different measure of liquidated damages than Dominion that is substantially lower. It is a good bit higher than my $5,000 number. And as I said, with respect to an issue like the guaranteed minimum output, I think that it would be reasonable to reach a similar conclusion with respect to both utilities in the state. I don't see any basis for them having different measures of liquidated damages.
I think Commissioner Williams covered a lot of them. I do want to touch on the due diligence period, the 30 days that you discussed. And I believe you may have proposed, is that one of the new terms that you proposed?
That's correct.
Why is that period reasonable? Why is that a reasonable period?
Well, one measure of reasonableness is the fact that Duke has proposed it and has incorporated it into virtually every PPA that I know of that Duke has ever executed in the Carolinas. But the underlying concept is simply this. Let me digress for a minute and say I believe that Dominion has also had some form of due diligence period, at least with respect to financing conditions in prior PPAs here. But the key notion is that there be some limited period of time in which pricing is firm and a QF can say, okay, I now know this is going to be the price. Let me get the affairs in order and now sign a binding commitment based on this price. So another way to accomplish that, and I'm not sure this is reflected in any of my testimony in this proceeding, but it's something that I proposed in other contexts, and including Michigan is currently in the middle of rulemaking related to LEO formation. But another way to accomplish the same thing is to require the utility to provide indicative pricing to the QF in advance of the PPA execution, and have that pricing be firm for a limited period of time. So you could either have the pricing be firm and then a period of time in which the QF could execute the agreement without a due diligence period, or you can sign the agreement and have the due diligence period embedded within the contract. But either way, it's designed to give the QF a very limited period of time after it knows what the pricing is to be able to make the final evaluation that, yes, it's prepared to enter into this agreement and make a commitment that would potentially expose it to damages if it fails to perform. I hope that was clear and responsive.
That does. That helps. Thank you. And in your summary, you were talking in the discussion with the LEO, and it's near the end of your summary. You said, my alternative suggestion is to require that if a system impact study agreement has been tendered by Dominion to the seller, it must have executed and returned it in a timely fashion. And what is your definition of timely fashion there?
I don't think there would be a lot of debate about that, whether it's, I'm not sure what's in the interconnection procedures here, but it may be 10 business days or 15 business days or something like a very quick turnaround time. But the key notion is, as FERC has held, and the FERC NOPR, by the way, does not modify this principle, you can't have a situation where a QF cannot form a LEO because the utility has not taken some action under the interconnection process. So a good example is what North Carolina Commission did, which was to say, okay, we think it's a good idea not to have LEOs be formed until the system impact study process has concluded. Under the North Carolina procedures, that's a 105-day period. So what the North Carolina Commission did was to say that in order to form a LEO, the QF must either have completed the system impact study process or 105 days must have passed. That way, if the utility is behind schedule and delays or is, for whatever reason, unable to complete the review in that period of time, the QF has not been precluded from forming a LEO because of the utility delays. And that's actually a concept that I proposed in the Duke proceeding, really trying to be responsive to the way they had structured their LEO form. Dominion's form was structured a little bit differently, so I tried to respond to that form. And the idea was, I don't have an objection to delaying LEO formation until a system impact study agreement has been formed, provided that the utility has gotten to the point of tendering that agreement. So that was the idea of the QF having to turn the agreement around. If the utility hasn't gotten to the point of tendering an agreement, then that shouldn't be a reason for precluding LEO formation.
Thank you very much. Thank you both for being here. That's all I have, Mr. Chairman.
Thank you. Commissioner Howard.
Mr. Chilton, good morning.
Good morning.
You made reference, and several other witnesses made reference to the possibility of escalated natural gas prices.
Yes.
Some of those escalations are pretty cheap. In your opinion, what would be the drivers to drive the cost of natural gas up?
I would say two or three come readily to mind. The first is that in the past couple of years, as the production of natural gas in the United States has risen and as prices have dropped for those producers, that they have expended a significant amount of money to build infrastructure to export natural gas production to South America, to Mexico, and outside of the United States. So as that demand market grows, the supply will have that pressure domestically, and prices should go up. I can understand why natural gas producers are looking at all sorts of markets to build demand and thus raise prices for themselves. I think that my understanding from just some fairly light reading on the subject, because I'm not a natural gas expert, is that many producers have invested in that export infrastructure in order to, as a sort of loss leader, that they aren't immediately seeing a return, but they expect to see a return over time. The second thing that comes readily to mind is that there has been an intensive exploitation of natural gas resources in the discovered reserves. There is not a consensus, there's not an opinion, from what I understand, again, I'm not a natural gas expert, that there are undiscovered reserves. And so what is being exploited are known reserves, and that in the next several years, but in the relatively near or middle term, that those resources will move from first generation exploitation to second and third generation exploitation, which is more expensive. And thus producers will have to raise their prices in order to cover the cost simply of producing at wells and reserves that are not just open it up and there it is, that they're going to have to invest in quite a bit more technology and materials in order to achieve the same level of volume. But again, I want to caveat that is about the extent of my natural gas expertise.
That's fine.
Thank you.
A couple of thoughts on this. I know there's a lot of conversation around Oklahoma on earthquakes caused by injection wells. Also, do you see any EPA regulations coming down that might affect the cost of natural gas?
I don't know that there are any proposed currently. I do know that there is continued concern and quite a bit of research on whether or not those two things are linked. And certainly there are environmental costs to fracking, for lack of a better term, that particular injection well technology, both in the chemicals used and in the effect on groundwater, not just on sort of seismic activity, but also just the ancillary environmental costs. It is possible. I don't really know much about EPA regulation. Steve might be able to speak more directly, but if there is not federal action, there may be state and local action that could also put pressure or limits on what a producer may be able to do, which could also be another driver. I would not expect that would, in the near term, be the primary driver of cost increases. I think it's more export markets and just the increasing cost of production.
Levitas, you want to comment? You look like you were.
Well, only to say that as you're thinking about the long-term interests of ratepayers in South Carolina, I think you should assume that there is a very high likelihood in maybe it's not in the next year, and perhaps it's not in the next 4 years after that, but sometime over the life of the horizon that you're planning for here, that the carbon and greenhouse gas implications of natural gas exploration and development and transport, in addition to the combustion impacts, will come under significant regulation.
Thank both of you. Appreciate your answers.
Thank you, sir.
Thank you, Commissioners. Any further questions? Mr. Adams, any redirect?
No, sir, Mr. Chairman, no redirect.
Thank you. Ms. Chilton, Mr. Levitas, thank you for your testimony, and you may step down, and you're excused. Okay, we've got next panel.
Chairman, we call Ed Burgess, Hamilton Davis, and John Downey to the stand, all for the Solar Business Alliance. We've got summaries of each of those three.
Okay, yeah, let's get those passed out up here, and then we'll get them sworn in, and we'll start.
Gentlemen, if you would raise your right hands, please. Do you solemnly affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth?
Mr. Chairman, we're going to start with Mr. Burgess here on the end. Mr. Burgess, please state your name and business address for the record.
Let's get your microphone on.
Mike. Maybe Hamilton, you could turn.
Yeah, does that work?
Yes.
Okay. My name is Edward Burgess. My business address is 2150 Alston Way, Berkeley, California.
And you work for whom?
Strategy Consulting.
And briefly, what do you do for them?
I am a senior director at Strategy, and I serve as a consultant in our consulting practice and working mostly with clients in both private and public sector and the power sector.
Are you the same Ed Burgess who caused direct testimony to be pre-filed in this proceeding on September 23, 2019, consisting of 95 pages?
Yes.
And are you also the same Ed Burgess who caused amended rebuttal testimony to be filed on October 12, 2019, consisting of 14 pages?
Yes.
And were both sets of your testimony prepared by you or under your direction?
Yes.
And do you have any corrections or changes to either set?
I do have one minor correction.
And that is to which set?
To the direct testimony.
Okay, can you tell us the page and line and just give us that change?
Yeah, I believe it's to page 76, line 19.
Okay, go ahead and tell us.
So it just should be, it stated turned within 2 hours. It should say turned on within 4 hours.
Okay, so noted. Mr. Burgess, if I now ask you the same questions that are set forth in your pre-filed direct and your pre-filed amended rebuttal testimony, your answers from the stand be the same today?
Yes.
Mr. Chairman, the Solar Business Alliance would ask that with that one correction that Mr. Burgess noted, that the pre-filed direct testimony and the pre-filed amended surrebuttal testimony of Ed Burgess be entered into the record as if given orally from the stand.
Mr. Burgess has corrected pre-filed direct testimony, and his amended surrebuttal testimony will be entered into the record as though given orally from the stand.
Thank you, Mr. Chairman. Mr. Chairman, the Solar Business Alliance would also ask that there are two exhibits of Mr. Burgess. The first one is, they're not titled in a consistent way, but I'm just going to give them to you here. The exhibit EAB-1, and then the other one is Exhibit Burgess 2. We would ask that both those be identified as marked.
Okay. Exhibits EAB-1 and then Exhibit Burgess 2 will be entered as hearing exhibit number 10.
Thank you, Mr. Chairman. And Mr. Burgess, have you prepared a summary of your direct testimony and surrebuttal testimony?
I have.
Could you give that to us now?
Yes. Okay, good morning, Commissioners. Thank you for the opportunity to appear here today. My direct testimony is organized into 6 sections. I'll summarize each of these 6, which can be grouped into 2 main parts. The first main part deals with certain high-level issues in this case. There are 3 key high-level issues that I address in this first part. Number 1 is the underlying utility incentive structures that may influence Dominion's proposed avoided cost rates in this proceeding. In this section, I explain why Dominion has an inherent incentive to pursue low avoided cost rates and thus limit the deployment of QF resources. This incentive for low avoided cost rates stems from the fact that QFs have the potential to displace utility-owned generation investments from which Dominion has the opportunity to earn a rate of return for its shareholders. Additionally, the incentive for low avoided cost rates also stems from the fact that Dominion has a robust natural gas business in the region, and QF resources would tend to reduce overall demand for natural gas throughput and related commodity sales. Number 2 of the high-level issues is the potential costs and risks to Dominion's customers from traditional utility-owned generation resources in contrast to third-party QF resources. This section addresses the fact that QFs present a lower risk profile to Dominion's customers since they are not subject to potential cost overruns, not subject to fuel price volatility, provide additional optionality when considering future resource investments, and have compensation that is tied to performance. Regarding costs to Dominion customers, I've also estimated the impact key elements of my proposal would have and found them to be relatively small. For example, removing the variable integration charge, at least until an independent study can be completed, would lead to a change in revenue requirement of less than 1%. Number 3 of the high-level issues is the importance of a technology-neutral approach to setting avoided cost rates, particularly in recognition of the rapidly changing technological capabilities of QF resources. Given that there are virtually limitless potential configurations of solar or solar plus storage, it does not make sense, in my view, to develop a separate avoided cost rate for each of these possibilities. A superior approach would be to quantify the value of delivering power to Dominion systems at different times and develop a set of rates that is agnostic to the underlying technology. This would mirror the approach taken by other utilities like Duke and is the approach I recommend be adopted in this proceeding. The second main part of my testimony provides a more detailed analysis and critique of the avoided cost rates that Dominion has proposed and also puts forward a set of alternative rate options for the Commission's consideration. There are 3 main rate components I address, each in a separate section of my testimony. They are the avoided energy cost rates, the avoided capacity cost rates, and the proposed integration charges. Throughout each of these, it is important to note that my analysis was hindered by a general lack of transparency and lack of data in Dominion's modeling of avoided costs. Initial responses to SBA's discovery requests yielded responses that were opaque, incomplete, or lacking any meaningful explanations or labels. This stood in stark contrast to Duke's responses, which we were analyzing concurrently, and although not perfect, were much more transparent. In the case of the integration cost analysis, I received critical data and information from Dominion, including a completely revised rate proposal only 1 business day before my direct testimony was due. Notwithstanding these issues, there are several deficiencies that I've identified in my testimony that I would like to bring to the Commission's attention. Regarding Dominion's proposed energy rates, the selection of 4 pricing periods was predetermined by Dominion, which has the potential to skew results for QFs with specific output profiles due to averaging. This contrasts with Duke's proposed 9 time periods and SBA's proposed 11 for Duke, which provides a much more granular approach and more accurate. Dominion was unable to provide the necessary data for us to make a determination about the appropriateness of its predetermined time periods or suggest alternatives. The energy rates also include an integration cost component that I believe is excessive and not adequately justified. The proposed rate for QFs with storage is identical to QFs without storage. This incorrectly estimates the ability for storage to increase a QF's energy value through optimal dispatch. Regarding Dominion's proposed capacity rates, first and foremost, I believe Dominion's incorrect in ascribing 0 capacity value to solar resources. 6 of Dominion's last 10 annual peaks occurred in summer when solar is plentiful. Even during Dominion's highest winter peak in recent years, I believe a solar facility could have a small contribution. Moreover, Dominion's own analysis shows a meaningful non-zero ELCC value for solar, which is the industry standard for measuring capacity value. In addition, Dominion's evaluation of capacity value relies on a completely different resource plan than what was used to evaluate energy rates. Finally, I believe the assumed capital costs selected by Dominion were too low. Regarding Dominion's proposed integration charges, my biggest concern is the fact that Dominion proposes 2 different charges with 2 completely different methods for calculating the supposed costs. One is embedded in energy rates, which I call the embedded integration charge. The other is a separate variable integration charge. By proposing the embedded charge, Dominion completely ignores its own study conducted by Navigant when calculating integration costs for future QFs. Instead, it relied on what appears to be a very rudimentary analysis of potential operating reserve needs based on a presumed 35% of solar nameplate value. Even the variable integration charge has flaws. More specifically, the study it relies on incorrectly assumes that Dominion operates as an island, does not sufficiently characterize the geographic diversity of solar, is overly restricted by an assumed 4-hour forecast window, appears to overestimate the operating reserve needs during non-solar or partial solar hours, and Dominion's witness even admits that certain practices like reserve sharing could mitigate these costs. Given these deficiencies, I recommend that the Commission reject Dominion's proposed integration charge as well as the integration cost component of Dominion's proposed solar QF rates until the independent study authorized by Act 62 is completed. Finally, taking into account all these issues, I present alternative approaches for calculating the avoided cost rates for energy and capacity that correct for some of the deficiencies described above. These are provided as a summary table as an exhibit in my surrebuttal testimony as an attached to this summary. Thank you.
Thank you, Mr. Burgess. Mr. Chairman, we'll move to Mr. Davis next. Mr. Davis, please state your name.
Hang on one second. Yes, I think we've got some. Okay, on his, we've got a public and confidential version of Mr. Burgess's testimony, correct?
That is correct.
And we need to make sure that we have the confidential part kept under seal. Is that correct? So what do we need to do? You need to move for it if you want it.
All right, so I would move to keep the confidential part under seal, effectively.
Read into the transcript.
And read into the transcript.
Okay, so we'll put the confidential part of the read into the record and read into the transcript.
Yes.
And maintained under seal.
And thank you for your assistance with that.
Thank you.
Adopt that, yes, sir.
Thank you, everybody that pulled those strings.
Yes, sir. All right, if we're turning back to Mr. Davis now, Mr. Chairman, are we good? Okay. Mr. Davis, please state your name and business address for the record.
Hamilton Davis, 1519 King Street, Charleston, South Carolina.
And you work for whom?
I'm the Director of Regulatory Affairs for Southern Current.
And what are your responsibilities there?
I oversee the company's engagement in regulatory proceedings like this in the states where we develop projects.
Yes, sir. And you're the same Hamilton Davis who calls testimony to be pre-filed in this case on September 23, 2019, consisting of 23 pages.
I am.
And the same Davis who calls surrebuttal to be filed in this proceeding on October the 11th, 2019, consisting of 8 pages.
I am.
And were both sets of your testimony prepared by you or under your direction?
They were.
Do you have any corrections or changes to either set?
I do not.
Mr. Davis, if I asked you the same questions that are set forth in your pre-file direct and sir rebuttal, would your answers from the stand be the same today?
They would be.
Mr. Chairman, the Solar Business Alliance would ask that pre-file direct testimony and the pre-file sir rebuttal testimony of Hamilton Davis be entered into the record as if given orally from the stand.
Mr. Davis's pre-file direct testimony and pre-file sir rebuttal testimony will be entered into the record as though given orally from the stand.
Thank you, Mr. Chairman. And Mr. Davis has no exhibits. I'll just point that out. Okay. Mr. Davis, have you prepared a summary of your pre-file direct and sir rebuttal?
Yes, I have.
Could you please provide that now?
I will. Mr. Chairman, Commissioners, Commission staff, it's good to be back in front of you guys again so soon. My direct testimony begins with an overview of South Carolina Act 62 as it relates to these proceedings, including the Act's goals and the authority and direction given to this commission therein. I illustrate how Act 62 is essentially a reset of utility regulation as it pertains to a range of issues related to the expansion of renewable energy generation and utility resource planning, and how it provides this commission with both increased direction and discretion in determining the most appropriate path forward for energy development in South Carolina. Further, I elaborate on the Act's goals in promoting South Carolina's policy of encouraging renewable energy, including the fact that this commission is directed to address all renewable energy issues in a fair and balanced manner that considers cost and benefits to all customers and establishes just and reasonable rates that reflect changes in the utility industry as a whole, while also recognizing and prioritizing increased competition and consumer choice within the state's electricity marketplace. I then discuss the risks and incentives for utilities, solar developers, and ratepayers inherent in both the traditional cost of service utility model and the solar business model enabled by Act 62 and the Public Utilities Regulatory Act of 1978, or PURPA. My testimony directly acknowledges the financial interest of the SBA in these proceedings and recognizes that it is this Commission's responsibility when evaluating the evidence in this proceeding to consider the financial incentives and biases that influence both solar developers and utilities. I point out that in the entirety of its direct testimony, nowhere does a single Dominion witness mention shareholder interests, incentives related to lower avoided cost, or the impact additional competition has on company profits. Rather, witness Raftery incredulously claims that Dominion is not incentivized to understate avoided cost. My testimony also emphasizes the often overlooked risks associated with utility-owned generation that do not exist for third-party owned solar generation. Because those risks are borne by small power producers rather than customers, and in other words, when generation is owned by small power producers, customers are shielded from those risks. The most obvious recent examples involve the abandonment of Lee and VC Summer nuclear units that left South Carolina ratepayers on the hook for billions of dollars. But even where projects are brought to completion, there's risk that the construction cost will exceed estimates, or the project will fail to deliver on time, or deliver less power, or deliver it less reliably than projected. There's additional risk that environmental costs will rise as new requirements or new liabilities arise. And a long-term PPA with a small power producer protects ratepayers from these risks because those contracts are performance-based. Small power producers are only paid for the power and capacity actually delivered to the grid. So if a solar project is abandoned midstream, like these nuclear units, they exceed cost projections or otherwise underperform, it's the small power producer that bears the cost, not the ratepayer. Coal ash management, cleanup, and accidents also expose customers to significant cost risk. Dominion's neighboring utility, Duke Energy, has estimated its coal ash-related liability in the Carolinas to be somewhere between $5.6 and $10.6 billion. Duke Energy has maintained that coal ash cleanup costs come hand in hand with the operation of coal-fired power plants and should therefore be recovered through rates. Similarly, Dominion Energy in Virginia has received legislative approval to recover upwards of $2.7 billion from customers in coal ash management costs. Solar has no such waste-related issue, but even if it did, Act 62 and PURPA-based contracts provide no avenue by which those costs could be passed along to utility customers. Over-reliance on natural gas generation also puts customers at risk of future fuel cost volatility, particularly as the current low natural gas prices are driven largely by the widespread use of hydraulic fracking. Future environmental regulations that impact fracking would likely lead to a significant increase in gas prices, and similarly, increased natural gas exports, potential CO2 pricing in the future, and additional state and federal environmental regulations could all impact natural gas prices. These are risks that Dominion's ratepayers will bear with additional planned investments in natural gas generation. Conversely, solar generation does not bring that same risk of future fuel price volatility. And if natural gas prices increase in the future relative to avoided cost rates, this could provide substantial savings to Dominion and its ratepayers. Finally, I provide an overview of PURPA and its implications for energy production in South Carolina. Similar to Act 62, PURPA was established in part to diversify electric generation resources by encouraging energy production from small power producers. Congress intended PURPA to shift a portion of electric generation away from resources built, owned, and rate-based by vertically integrated monopoly electric utilities that often resulted in cost overruns paid by ratepayers. Among other goals like energy conservation and efficiency, PURPA was intended to inject limited competition into monopsony energy markets where the only legal opportunity for small power producers to sell electricity is to a monopoly utility. My surrebuttal testimony is primarily a refutation of a number of claims made by Dominion witness Raftery in his rebuttal testimony. Witness Raftery claims in his rebuttal testimony that I suggest that Act 62 requires customers to somehow subsidize and assume the risk associated with renewable resources. This is incorrect, and that my direct testimony explicitly stated that this commission is directed to address all renewable energy issues in a fair and balanced manner that considers cost and benefits to all customers and establishes just and reasonable rates that reflect changes in the utility industry as a whole. My direct testimony also pointed out that any decisions by this commission shall strive to reduce the risk placed on the using and consuming public. My surrebuttal testimony also refutes witness Raftery's claim that Act 62 does not represent a shift away from a business-as-usual regulatory approach. Act 62 significantly increases the commission oversight and utility transparency required in avoided cost proceedings, while also requiring that small power producers be treated in a non-discriminatory manner. The statute includes a new directive that in setting avoided cost rates, the commission shall treat small power producers on a fair and equal footing with electrical utility-owned resources. In addition, specific requirements related to energy storage, ancillary services, commission use of independent third-party experts, commercially reasonable contract terms, and contract tenor all reflect statutory changes that signify South Carolina's shift away from business-as-usual regulatory approach to avoided cost proceedings. In addition, the statute includes new requirements that increase the level of transparency and scrutiny of the utilities' integrated resource plans, which are critical input for avoided cost calculations. Although witness Raftery's rebuttal testimony claims that solar does not compete with the utility for the opportunity to build new generation, I point out the various ways in which his opinion on this matter is flawed and contrary to the plain evidence, including witness Raftery's disregard for the fact that the company's avoided costs calculations are disputed in this proceeding and that the capacity contribution from solar is an issue that will be resolved by this commission. Notably, ORS witness Ori's testimony recommends significant changes to the avoided capacity calculation produced by Dominion, which results in substantial additional capacity value being credited to solar. The rationale underpinning avoided capacity payments is in large part to provide small power producers with payments for utility capacity needs that are either delayed or would otherwise be borne by ratepayers for utility-built generation. Additionally, when more of Dominion's system energy needs are met by QF Solar, fewer megawatt hours must be met by the company's generating units, which delays or avoids the need for future investments in baseload and intermediate type power plants in favor of lower cost peaking plants. Thus, small power producers compete with Dominion for generation on an energy basis regardless of capacity benefits. And since baseload and intermediate plants are more complex in their design and construction and have a larger upfront capital cost than peakers, energy from small power producers likewise provides a risk hedge to customers as it relates to utility development and ownership of generation. Witness Raftery also ignores the role of storage and its ability to provide capacity when it is needed by the company. Storage resources are an integral part of Act 62, and this proceeding Yet the value and flexibility of storage resources in witness Raftery's rebuttal testimony is limited to a reference to the merger settlement agreement and the company's intention to file storage programs with this commission after the current proceeding has concluded and prior to December 31st, 2019. My rebuttal testimony also disputes witness Raftery's claim that the state's Siting Act effectively insulates customers from the types of risks outlined in my direct testimony, and despite witness Raftery's claims to the contrary, I note that this commission is explicitly directed by Act 62 to strive to reduce the risk placed on the using and consuming public. That includes reducing risk from utility-owned generation through deployment of small power producer-owned renewable resources. And finally, in response to witness Raftery's claims that small power producers are incentivized to seek the highest possible avoided cost in order to maximize returns for our investors, I point out that the SBA represents member companies that also compete against each other, as well as utilities, and we advocate that avoided cost rates should be just and reasonable and should, to the extent possible, accurately reflect the cost being avoided by the utility. There is a finite amount of land in South Carolina suitable for solar development, and the capacity needs that small power producers can effectively displace in a utility system is also finite. Arbitrarily high avoided cost rates can encourage market entry by power producers that could not otherwise compete in a lower cost environment. Competition should and does drive down cost over time, and this is to the benefit of ratepayers as well as to small power producers that are able to effectively manage cost in a competitive, lower cost environment. Thank you. That concludes my summary.
Thank you, Mr. Davis. Mr. Chairman, may I turn to Mr. Downey now? Mr. Downey, please state your name and business address for the record.
My name is John Downey, 1519 King Street in Charleston.
And you work for whom?
I work for Southern Current. I'm the president and CEO.
Just 30 seconds on what you do there. Any more than that?
So I manage the operations and finance of the company and all of our employees.
Very good. Are you the same John Downey who caused testimony to be pre-filed in this proceeding on September 23, 2019, consisting of 15 pages?
I am.
And was that testimony prepared by you or under your direction?
It was.
Any corrections or changes?
No.
Mr. Downey, if I asked you now the same questions that are set forth in your pre-filed direct testimony, would your answers be the same today?
They would.
Mr. Chairman, the Solar Business Alliance would ask that pre-filed direct testimony of John Downey be entered into the record as if given orally from the stand.
Mr. Downey's pre-filed direct testimony will be entered into the record as though given orally from the stand.
Thank you, Mr. Chairman. We have no exhibits for Mr. Downey.
Thank you.
Mr. Downey, have you prepared a summary of your testimony?
I have.
We'd like to hear that now, please.
Okay. Mr. Chairman, commissioners, and commission staff, it's good to be here with all of you today. As a business owner and the CEO of a successful energy company, my testimony is intended to provide this commission with additional insight into the economic development perspective of companies like Southern Current, including the operational processes, risks, and underlying regulatory and policy frameworks that support increased competition in electric generation. In addition, my testimony explains how businesses like Southern Current help to elevate South Carolina's economic competitiveness and deliver value to ratepayers by reducing risk and increasing stability in electricity rates. Southern Current employs over 100 full-time employees here in South Carolina, and we continue to grow our workforce as state markets like South Carolina begin to foster additional investment opportunities to increase competition. To date, Southern Current has sold over $1 billion of solar assets, and we currently have a development pipeline of over 3 gigawatts across multiple states. My written testimony provides a more complete overview of Southern Current and a high-level description of the company's investment portfolio of solar assets, as well as an outline of the steps and investments necessary to bring a solar project to the point of executing a power purchase agreement, including the financial risks assumed by solar developers. My testimony then contrasts the risk from third-party owned solar assets with the risk borne by ratepayers under the traditional cost of service utility business model. Southern Current, like many solar developers, takes on substantial capital risk to develop and construct energy facilities. As a privately held company, we use a combination of internal capital and debt to develop and construct projects, in addition to arranging long-term financing and tax equity investment for a project's lifetime. My testimony identifies a spectrum of investment risk taken by solar developers within the time and capital-intensive process of bringing a typical project to the point where a PPA can be executed. Unlike a regulated utility, we develop projects with no guarantees that our costs will be recovered. Because we are only paid for power delivered to the grid, we take on all costs associated with financing, construction, project in-service deadlines, and contract penalties, including guaranteed uptime delivery of power, all before the project is deemed completed. As noted above, since we don't have a captive customer base, any construction cost overruns, finance premiums, unforeseen maintenance issues, and the like are borne by Southern Current with no chance to change the price we are paid for power. Ultimately, solar developers like Southern Current knowingly take on these risks so that we have an opportunity to compete for electricity sales in this type of market. All project revenue paid to a solar developer is determined by the avoided cost rates approved by this commission, which are fixed in the PPA and not subject to upward adjustment for unforeseen costs associated with interconnection, permitting, construction, maintenance and operations, regulatory requirements related to emissions and waste management, or any other potential cost adders. By having the solar developer bear these cost risks, ratepayers are shielded from escalating project costs that can accompany utility-owned generation resources. Ultimately, the Act 62 and PURPA-based development model requires a solar developer to mitigate impacts to its profitability by properly managing project development, as well as assuming the risk associated with final interconnection costs, while also providing utility customers with the predictability that follows from fixed-rate avoided cost contracts. Finally, my testimony explains the importance of state and federal policies like Act 62 and PURPA for enabling effective competition in monopsony energy markets like South Carolina, as well as the spectrum of benefits that flow from that competition to the state's businesses and citizens. In the wake of V.C. Sumner and Lee nuclear abandonments, Act 62 was passed unanimously by the General Assembly with the benefit of competition and consumer choice in mind. Proper implementation of Act 62 will do many things, but most importantly, it will continue to expand a marketplace that historically has been limiting for small power producers. The intent of PURPA in 1978 to allow for competition in monopsony markets by small power producers is similar in many ways to the intent of Act 62. It was Congress's conclusion that allowing such competition would ultimately benefit American utility ratepayers. Proper implementation of Act 62 and PURPA in South Carolina means businesses like Southern Current have the opportunity to compete and that customers receive the benefits of that competition. South Carolina is also known for its strong manufacturing base and is home to a diversity of national and international companies. Increasingly, large commercial and industrial customers demand the opportunity to purchase renewable energy to both meet corporate sustainability goals and reduce operating expenses. As this trend continues, renewable energy will increasingly become a tool for economic development and retaining and attracting business to the state. In recent years, South Carolina has experienced the realities and consequences of long-term maintenance environmental cleanup costs related to older fossil-based generation, in addition to the costs of project abandonment. Much of these costs are often passed on directly to customers, but were never fully considered and accounted for when these projects were approved by regulators. By comparison, independent ownership of generation, and specifically solar, places the cost of items like decommissioning, abandonment, and environmental cleanup on the solar developer and not the ratepayer. Finally, Southern Current is a large employer, taxpayer, and utility customer headquartered in South Carolina that has a vested interest in the energy future of this state independent of our solar business model. Like all businesses, we want access to predictable, low-cost, and reliable electricity. We want South Carolina to promote environmentally sound and socially responsible policies, and we want the state to thrive economically in the 21st century. We believe Southern Current and the solar industry play an instrumental role in preserving and enhancing all that makes South Carolina the great state that it is today.
Thank you, Mr. Downey. Mr. Chairman, our witnesses are available for cross and for commission questions.
Thank you. Any cross?
I have a few questions.
Okay.
Good morning, gentlemen. These questions are for Mr. Davis. Mr. Davis, you would agree with me that Act 62 requires the Commission to approve an avoided cost methodology for Dominion Energy South Carolina in this docket, correct?
I would.
Okay. And Act 62 defines avoided cost, correct?
It does, through reference to PURPA, as well as discussing additional issues that the Commission should be considering, like risk to ratepayers. And, you know, there's context for this proceeding.
Could somebody help me with the Elmo?
Need the Elmo? Mr. Gissendan, I want to make sure you get in front of that microphone too a little bit more so you can be heard better.
Mr. Hamilton, could you please read the definition of avoided cost from Act 62?
Avoided cost means the incremental cost to an electric utility of electric energy or capacity, or both, which, but for the purchase of the but for the purchase from the qualifying facility or qualifying facilities, such utility would generate itself or purchase from another source.
Thank you. And you mentioned that this definition was borrowed from PURPA. Are there any changes between this definition and the PURPA definition?
I'm not sure if it's word for word from PURPA.
This is the PURPA definition of avoided cost. Could you please read that for everyone?
Sure. Avoided cost means the incremental cost to an electric utility or electric energy or capacity, or both, which, but for the purchase from the qualifying facility or qualifying facilities, such utility would generate itself or purchase from another source.
And would you agree with me that that is verbatim the definition that is in Act 62?
It seems to be verbatim.
Thank you. So you would agree with me that Act 62 didn't reset the definition of avoided cost, correct?
I would also state that I didn't claim in my testimony that it restated the definition of avoided cost.
Thank you. And so the utility had to determine its incremental cost before Act 62, and it still has to determine its incremental cost under Act 62.
Yeah, I think what's changed is that the legislature looked at what was being produced out of previous avoided cost proceedings and recognized that additional statutory guidance was needed here. And so what you see is a much more robust set of requirements for transparency and considerations, energy storage, ancillary services that this commission now is to take into consideration, as well as availing themselves of the opportunity to things like third-party expertise to help with that analysis.
Okay, but the definition of avoided cost did not change, as you've already agreed, and nothing in the definition of avoided cost in either Act 62 or under PURPA references the ability of the QF to obtain financing. Is that correct?
PURPA references the ability of the implementation of PURPA through FERC references the ability of QF to obtain financing. And again, the definition of avoided cost is different than how we calculate and come to that number. So that is what has changed.
The definition of avoided cost under PURPA and Act 62, as you've read to the commission, does not reference.
And I'm not being argumentative. I agree that the definition has not changed. How avoided costs are calculated has changed.
Mr. Hamilton, would you agree with me that long-term purchases that a utility makes necessarily impact avoided cost rates?
I'm sorry, could you ask that again?
When a utility makes a long-term purchase, that affects avoided cost rates going forward.
Presumably, the utility, when it does its resource planning and as you guys do differential revenue requirement, will take into account those long-term purchases, and it will have an impact on avoided cost rates moving forward.
Thank you. And you are a representative of Southern Current. You work for Southern Current, correct?
I'm employed by Southern Current.
And are you aware that in 2018, Southern Current executed 4 contracts on May 26th, 2018, totaling approximately 35 megawatts?
I do not track our PP execution, so I'm not familiar with that, no.
What about you, Mr. Burgess? Are you aware? Oh, sorry.
I'm sorry, go ahead.
Oh, I'm sorry. Was it? Mr. Burgess, you're the CEO of Southern Current, correct?
That'd be me.
I'm sorry. I'm sorry, Mr. Downey. Mr. Downey, you're the, and you're aware of those 4 contracts. They were executed on May 26th after the commission approved the latest avoided cost rate in the order that was issued on May 2nd of 2018.
I'm not sure exactly of the timing, but I know that we did execute a number of PPAs around that time.
You would agree with me that this is the version that was filed with the commission?
We got to get you in front of the microphone.
You would agree with me that this is the version of one of those contracts that was filed with the commission for Trask East Solar on May 26, 2018. I can provide you with a copy.
It appears to be.
Okay. Thank you. And Mr. Davis, would you accept, subject to check, that the commission issued its order in docket number 2018-2E, the 2018 fuel proceeding on May 2nd, 2018? That's order number 322A.
Subject to check.
And so you would agree with me that if the company entered into these contracts after the commission order establishing the avoided cost rate, that these contracts could not have been reflected in the avoided cost rate that was updated in that order.
I'm sorry, could you repeat the question?
These contracts were executed on May 26th, 24 days after the commission issued its order updating the avoided cost rates. Given that these were executed after the avoided cost rates were updated, you would agree with me that these contracts could not be reflected in those avoided cost rates?
Yeah, I mean, presumably when the commission issues an order adopting avoided cost rates, it will be available for PPAs after that date and not before. So it would be illogical to think those have been included within avoided cost rate calculation.
And since you're here on behalf of the Solar Business Alliance, are you also aware that Cypress Creek executed 2 PPAs for Beulah Solar and Kepler Solar, totaling 74.97 megawatts apiece on May 29th, 2018?
I was not aware of that.
And also, are you aware that Eastover Solar executed a PPA at the current avoided cost rates that were filed with the PSC, and that filing was filed with the commission in docket number 2019-229E?
I was not aware of that either.
Thank you. One final thing, Mr. Hamilton, I noticed in your summary that you indicated that there was a finite amount of land in South Carolina suitable for solar development. And Commissioner Irvin has talked a lot about technology, flexible solar, battery storage. shouldn't we take this into account, the finite amount of land available for solar development, when we are setting avoided cost rates?
I'm not sure how it would be taken into account other than recognizing that there's competition within the industry for viable land, viable solar sites.
You would agree with me that if the commission were to set rates that are higher than they should be, and encourage, as you said arbitrarily high avoided cost rates, encourage market entry by power producers that could not otherwise compete in a lower cost environment. So to the extent that the avoided cost rates are not set correctly and they're set high, we're encouraging that finite amount of land to be used up before these other technologies can be explored. Isn't that correct?
Well, I think we're just in a situation where what we're looking for is accurate avoided cost rates. I mean, this is the market construct that the legislature has preferred through the new legislation. There are, and this discussion was had with the commission, and maybe we can get back into this again, but the idea of flexibility for future technological changes has certainly been considered by SBA. It's part of what Mr. Burgess testifies to as it relates to technology neutral rates. And Duke accommodates this, the addition of storage within their avoided cost rates. It's exactly the type of flexibility that we prefer, so that as technology changes, we're able to take advantage of that in the state, and utility customers are able to appreciate those changes.
Thank you, Mr. Davis.
Thank you. Any other cross for these? Commissioners?
Mr. Chairman.
Williams.
Good afternoon, gentlemen. Well, not quite afternoon. So I want to talk to all of you. I have a couple of questions for Mr. Burgess at the end, but I want to talk to all of you just to sort of flesh out what you think is going on here, not only in this proceeding, but with Act 62. So South Carolina Code annotated Section 58-41-20, paragraph J reads as follows: Each electrical utility's avoided cost filing must be reasonably transparent so that underlying assumptions, data, and results can be independently reviewed and verified by the parties and the commission, period. There's another sentence that's not pertinent to my question. In your opinion, has Dominion met the standard in the paragraph I just read, or the sentence I just read from paragraph J?
Obviously there's some subjectivity there, but my personal opinion was that I found it very challenging, and there was a lack of transparency in dealing with some of the data and information that was provided by Dominion to SBA in this proceeding. Whether or not it meets that legal definition, I'm not a lawyer, so I wouldn't speak to that, but certainly, as I mentioned in my summary, there's certain information that was either opaque or unclear or lacking in description when it was provided to us, or even just missing information. And some of the underlying analysis we've requested information on. I think we requested additional reruns of the modeling that were not provided, and that was, I think, critical to us in providing a complete analysis of what was proposed here, and we were unable to do that based on the information provided.
I've been involved in these proceedings for a while. I was here last year, and I mean, my experience, and I think that the company has been transparent about this. They're approaching this proceeding the same way they've always approached this proceeding, and the same issues that have arisen in the past, some of which are being dealt with in the courts right now, still exist as it relates to transparency and the challenges with being able to produce an adequate analysis and alternative recommendations and considerations for this commission are still here.
So, put simply, the company, from your perspective, is using a business as usual approach?
I think that they've certified that they're using a business as usual approach, and they think that Act 62 reflects a business as usual direction for the state.
Sir, do you have any commentary, Mr. Downey?
I'll defer to the experts on this one.
Okay. In your opinion, does Act 62 support a business as usual approach to these proceedings?
I think almost the entirety of Act 62 is a referendum on how this commission and how the legislature thinks about renewable energy in this state. It across the board addresses the ways in which customers access renewable energy, how that energy is valued, from commercial industrial to residential to community solar, and certainly in this proceeding, there's very clear statutory direction as it relates to transparency, as it relates to other and new issues that have never really been dealt with here, like storage, ancillary services. So it's difficult for me to see how you could read that statute and not appreciate that we're in a new environment. And I think, how busy all of you have been and we've been over the last few months, 6 months since the statute passed, is an indication that we're not simply rerunning what's been done in the past.
What's interesting about Act 62 to me is that it requires the commission's expert, who is not a lawyer, to make a statement in his report, and I'm referencing paragraph E, subparagraph 3 in South Carolina Code annotated 58-41-20. It requires our expert to make a statement assessing the level of cooperation received from the utility during the development of the report. And obviously, as you all know, our expert is going to render a report. I'm concerned, based on your opinions, that the company has not been as transparent as Act 62 would require them to be. Do you think an argument could be made that the company does not take Act 62 seriously?
I think the company has not followed the requirements as laid out in Act 62. Whether they take it seriously or not, I'm sure they take it seriously. But clearly, they've got a different opinion of what the plain language of the statute says than SBA does.
And you think that stems from a business as usual approach? Obviously, you don't work for the company. I'm simply asking your opinion based on your experience.
My opinion, based on my interaction with the company and reading their testimony, is that they continue to view us in a business as usual situation in South Carolina as it relates to these proceedings. I think that was the line of questioning that I just received from Attorney Gissendanner related to the definition of avoided cost. The point he was making is nothing's changed.
All right. So, Mr. Burgess, I have some questions for you specifically. You have offered comment on the reviewability and transparency of Dominion's avoided cost analysis, recognizing that the review of a utility's avoided cost filings is a biannual process. Do you have any recommendations for the Commission on what could be done to enhance the transparency of Dominion Energy's filings with respect to avoided costs?
You mean for future avoided cost proceedings?
Yes, sir.
Yeah. I certainly have ideas. Off the top of my head, I'd have to give it some thought. But I think certainly there's certain types of data that could be provided in terms of the modeling that's been done by Dominion and could be provided, I think, in a way similar to the way Duke has provided it, which would provide some consistency and increased transparency around that data. So, as by way of example, Duke has provided much more granular, hourly avoided cost data that was not provided by Dominion. That's just one example that comes to mind, as something that could be provided, but I'm sure I could come up with a long list of recommendations there if it's something the Commission's interested in. Just probably would need some time to think about that.
Could I just add one thing to that? I think the E3 witness, witness Ori, and as well as this commission has recognized in the past that timing makes some of this difficult. And of course, we've been under severe time constraints because of the requirements of Act 62. That's not necessarily the case moving forward. We'll have a 2-year window. I think appropriately staging these proceedings so that when there are disputes, they can be resolved in a time-effective manner rather than ending up here where we still don't have the information that will be useful for our analysis.
And I want to just clarify, when you say you still don't have the information for your analysis, are you referencing an outstanding discovery request, or that was a Mr. Davis? You just said you still don't have the information to make your analysis.
Yeah, so I would like to, I'm not doing the analysis, so I would like to let our expert comment on what he doesn't have currently.
Okay.
Right. So that, I mean, there's things that we've requested that Dominion has since provided after some back and forth. There's other categories of information that we still don't have that would be nice to have to, allow us to do a more robust analysis. I just mentioned one example, but there's others included in that. For example, I mentioned in my summary too, the analysis Dominion did on their integration costs that was provided literally one business day, before our direct testimony was due. We didn't have a chance really to ask discovery questions around that and, get information back on how that analysis was done or other relevant information. So, that information's missing. We, simply ran out of time really to get to the bottom of that. And there's likely others, that we could probably put in that bucket too.
Okay. And again, I'm going back to you, Mr. Burgess. I see.
1 second, Mr. Gissendanner.
The company would simply note that we have answered all of the SBA's discovery. There was a motion to compel that was subsequently withdrawn, and we would also note that the Commission's own expert submitted discovery requesting the exact information that the SBA is now saying that they did not have, and we responded to that and received a response back from the Commission's expert indicating that they did in fact have the information and had access to the files that SBA is now complaining about. So no pending motion to compel. We've answered every question, and they've gotten every bit of information that they've asked for.
Mr. Chairman, the withdrawal.
Wait, you got to get in the microphone.
Is that on?
Yeah, that's probably best.
Chairman, the fact that the motion to compel has been withdrawn does not mean that their responses are all adequate, right? I mean, there are reasons to, withdraw a motion to compel just to move the proceeding along, but I think if Mr. Burgess has asked questions by a commissioner about whether or not he thinks he was provided adequate information, he's allowed to answer that question. That's all he did.
Mr. Chairman, if the SBA feels that the information that Dominion Energy provided was inadequate, then it should have maintained its motion to compel. It withdrew it. That's how it works.
I can say the same point again. The fact that the motion was withdrawn does not mean that everything has been adequately provided, and I'll just leave it at that.
Okay, thank you. All right, let's continue, Commissioner Williams.
I'm not trying to start a fight. I'm just trying to get everything out on the record. So, Mr. Burgess, again, you called into question the reasonableness of the avoided energy cost pricing periods proposed by Dominion in this proceeding. I believe you indicated that you were unable to perform any analysis regarding the appropriateness of these periods. How can you be certain that these periods are unreasonable?
Well, I mean, that's just that we didn't have the granular enough information to make a determination about whether or not they were reasonable or not. And what, Dominion has provided to us, they've mentioned that these were essentially predetermined periods that were baked into the model. There was no way to sort of unpack other potential pricing periods or other more granular pricing periods. So, we simply, got the model results after those pricing periods were put in as assumptions, and, there's no way to back out, a different alternative from that. Like I mentioned, in contrast with Duke, we were able to unpack that to some degree because they provided more granular, detailed information, and that just wasn't possible in Dominion's case.
I noticed that several members of the panel, or at least two members of the panel, referenced what Duke provided compared to what Dominion provided. What difference does that make? I mean, we're here talking about Dominion. You're referencing Duke. Is there some inference the commission should make about the difference in the information provided?
I think it's just a comment on, we're dealing with these proceedings that, SBA and myself as their expert at the same time, and it's easy to compare the differences in information that we're getting, and there seems to be a pretty clear contrast in the sort of clarity and the granularity of information that we're getting from the two companies.
Were you all asking the same questions in both? Were the questions identical?
They weren't exactly identical because they were different proposals, but we explored similar issues and tried to get to the bottom of similar types of issues in both cases. Yeah.
So is it your position that because Duke provided the information in a more granular level, that Dominion should have done the same or had the capability of doing the same?
Yeah, I don't see any reason why they wouldn't be able to provide the same information.
Okay. In Burgess Exhibit 2 to your rebuttal testimony, you offer proposed avoided cost rates. You have proposed avoided cost energy costs roughly double those proposed by Dominion. How did you derive these rates?
Sorry, you're saying that the avoided energy cost rates I propose are double what Dominion has? Is that what you're asking? And
right.
Right. So for the energy rates, the only change we recommended in what we proposed, given that we had limited information, was to put forward avoided energy cost rates that remove the integration cost component. That was really the only modification that we made to those energy rates, and so Dominion had provided information on the energy rates prior to the integration costs being included, and then after they included those, and so we simply removed that element, and then that's where we landed.
All right, gentlemen, thank you for your responses to my questions.
Thank you. Thank you, commissioners. Commissioner Irvin.
Thank you, Mr. Chairman. Mr. Burgess, do you have an opinion as to whether or not the company's increase in reserve requirement of 35% is reasonable?
I don't think it's reasonable because there's no complete integration study that's been done to support that. It's inferred that because of some observations, in these solar generation units that Dominion has on their system, that's what would be appropriate. But there's a lot of factors in how the system is operated that contribute to the need for operating reserves, and solar is one of them, but it's not the only thing. So to make this presumption that there's a sort of one-to-one correspondence is inappropriate in my view, and I think completely ignores the fact that they did do a robust integration study. The Navigant study was done and led to didn't have any assumed 35% number within it.
Where did that 35% number come from if their own expert didn't use it?
So that, my understanding, and like as mentioned, the analysis behind that was provided at a very late date in this proceeding. But my understanding is that that's based upon observations Dominion has taken from solar facilities on their fleet, and some of the instantaneous kind of reductions in output that may have occurred over a period of time. And so, they then calculated 35% as a percent of the nameplate value of the solar based on those observations and the reduction in output.
Now, in your summary, I see that you've recommended that an independent study be required or requested by the commission on these proposed integration charges. You're aware of the time restraints we have as it relates to the implementation of the act. How can that be done at this late date, or can it be done at this late date?
For this current proceeding, it might not be possible. I recognize that there are those time constraints. But I think in general, perhaps for future proceedings, it's a good practice to consider. And, in fact, I think our recommendation was not to include the integration charge now, given that, there's not a whole lot of evidence, even in other places where there, is a lot of solar on the system, that these integration costs sort of go up as quickly as suggested. So I think that there's not a great risk in my mind to sort of putting that off until the time where it can be done.
What part of the overall cost are we talking about? If we thought that was a reasonable approach, is it going to have an impact on the company, substantial impact?
I don't think so. We, in my direct testimony, I did do an estimate of what the impact on revenue requirement would be if their proposed variable integration charge were included, or if it were removed, as in our proposal. And, I estimated it would be less than 1% of the total revenue requirement impact. So, and, that's for, the assumed 1,000 megawatt level or so of solar deployment. So, you could come up with different estimates with different assumptions, but, I think that it's a small impact. And again, that's the purpose of the integration charge, is to offset these future integration costs, which we don't necessarily know are going to materialize. So, the potential cost is sort of unknown at this point, but the potential revenue to be collected through this integration charge would be fixed and would have a material impact on solar developers in the state, including SBA members.
Are you saying that it would be fixed for the duration of the term, whatever that term would be?
Yeah, that's my understanding.
It could not be changed once it's implemented, or could not be adjusted?
Well, yeah, right. I mean, I think it depends on the terms of the PPA and all that, but one way to do it would be through a fixed approach, yeah.
Thank you.
Thank you. Commissioner Belzer.
Thank you, Mr. Chairman. Mr. Burgess. Mr. Burgess or Dr. Burgess?
Mr.
Regarding the pricing periods, and Dominion had proposed 4, and you mentioned that Duke had proposed 9, and y'all had, SBA proposed 11 in the Duke proceeding. If 4 is too small, what is a good number or an optimum number or reflective number of pricing periods for solar?
Yeah, good question. I mean, in the extreme case, you could do as much as hourly pricing. You'd have, 870, 60 pricing periods for a full year. That may not be appropriate or manageable to do. So, often utilities will average hours together, and that's how you get to these different pricing periods. And so, in the case of Duke, they've selected 9. It's somewhat subjective, what the right amount is, but that seems to better capture periods that have similar pricing. And so you could envision the same kind of thing for Dominion. And the problem with selecting too few is that you can average costs together in an inappropriate way. For example, if you have very low avoided costs at nighttime when demand is low on the system, and if those are averaged over part of the daytime, then you can have sort of a lower avoided cost rate for that daytime period, and then that doesn't adequately compensate the QFs for the generation they're providing during that time.
So are you saying that too few artificially skews avoided costs to the low end?
It can, it could skew the other way too. It's just we have no way of knowing without the underlying data, which we don't have from Dominion.
And I'm not talking about every hour of every day, but what is a realistic optimum number that would be beneficial to the solar power producers and not unduly burdensome to the utility? Do you have a recommendation?
Without seeing that sort of underlying hourly data, it's difficult to say with certainty what the right number would be, because you would want to try to select pricing periods that group together similarly priced hours, and we just don't have that information. But I think that certainly more than 4 is what I would look to.
Do you think 4 is unreasonable, unreasonably low, or few?
I think, given where we're going today, I don't think we're in a different situation where we have lots of ability to process this type of data and information in a way that we may not have when PURPA was adopted. So I think certainly, 4 seems too low to me, and I think it would be, potentially unreasonable, but I have to look at that underlying data. Yeah.
You mentioned that when you got the data, that there were predetermined time frames and that these 4 pricing periods were already predetermined. Do you recall answering Commissioner Williams? How did you get that information?
About the fact that they're predetermined? That was conveyed to us from one of Dominion's responses to our discovery request.
A written response?
I believe so, yeah. I can try to track that down for you.
Mr. Chairman, I'd ask for a late filed exhibit with that response regarding the predetermined pricing periods.
Get that. So late filed exhibit number 11.
Thank you, Mr. Burgess. Mr. Davis, you were here yesterday, were you not?
I was.
And did you pay attention to the testimony?
Closely. Let's see. You can test my memory, though.
Did you hear questions of witnesses asking if power purchase agreements had been signed following the April 2018 fuel docket order?
I did.
And did you hear any of the any responses in providing reference to any of the PPAs that were asked about this morning?
I didn't. I think the response we heard from witness Cassis and maybe Raftery was that there were no, or witness Neely, that there were no current PPAs that have been executed after that 2018 rate. I'm not familiar with the PPAs that were referenced by
or they
Mr.
weren't
Gissendaner.
Sure.
Yeah.
I think I heard a weren't sure too.
I think there was some equivocating, but
okay. Yeah. I think that's all I have. And then, Mr. Downey, I don't want to leave you out.
I'm not just a pretty face.
Well, I appreciate your position, and can you describe some of the risks that your company as a solar provider assumes prior to interconnection?
Sure. So,
I like the graphs at your testimony.
Oh, good. Thank you. But a big part of what we do as developers is try to mitigate that risk. So, but there's certain amount of risk we have to take on, especially early stage in the process. I think initially acquiring the right land is a huge piece for us, and that does take real money out the door. We try to do as much diligence on that as we can prior. But the reality is, until we get studies at least underway with the utilities to understand really what their costs, the interconnection costs are going to be, everything we do up to getting those numbers back is really at risk. And that is many thousands of dollars as we're undertaking studies to make sure that even we have to do the kind of the initial environmentals and pieces like that, just very kind of initial things to make sure. And I think the number that's out there is something in the neighborhood of $15,000 a project prior to us really understanding if they're going to be feasible from the utilities interconnection perspective, which doesn't sound like a ton of money until you start looking at the hundreds of projects that we're doing at any one time. So that and that is really where we have to have adequate hit rates, because what I think is difficult is that if we miss too much with that can put us under. So we've got to be very good on the front end. The contracting piece of it, and at the end of the day, we're taking a risk as well that the utilities, as we go into these hearings, because these are years-long processes, we take the risk as well that the utilities are going to provide us with the fair and adequate avoided cost rates. And that's really all we're asking for, is what is fair in the market. If I can't make the real avoided costs work for these projects, I made a bad bet. But what I have a problem with is making a fictitious, not being able to make a fictitious avoided cost rate work, and then losing my bet. And that's really where we are, is, and the as we look at some of the additional kind of impediments that have been put up in different places, and this is not about interconnection, but along interconnection processes and things like that. I mean, there's all sorts of risks that go along with that we're investing all along the way.
Let me ask you this. What challenges are you facing when raising capital for these projects, especially prior to executing a PPA? Let's look at prior to PPA first, and then we'll.
So prior to executing the PPA, and this is specific to South Carolina, the main things are what are the chances that the rate is going to change from what we are saying it is at this point? So what are the chances that avoided costs are going to go down? Because at the end of the day, this is just math for the investors that we bring in. What are the chances that the interconnection processes are going to change or be delayed? Because delay is a big part of this as well, as we're competing for capital. I think the important thing that gets lost sometimes is the fact that, when I'm out there trying to raise money for projects, it's not just South Carolina projects that I'm competing against for that capital. It's all across the country that we're competing with to try to get capital into South Carolina to help us build this infrastructure here. And when those financing parties take a look at it and they say, well, you know what, Duke or Dominion, I'm sorry, I almost said C&G again. Duke and Dominion are slow. They're fighting, to get avoided costs to rates that just don't make sense nationally or don't make sense within this market itself. Investors are going to take their money elsewhere. So the pool gets smaller and smaller. And that's what, frankly, we're running into, is that the pool of capital that is interested in deploying here is getting smaller. And this is one thing I think with, getting the act passed in the spring, I think was a great step forward to show, and it's something I use every day, to tell these investors, we're serious about this. This is a great way to invest in South Carolina. It also has been great as we're talking to large C&I customers, the commercial industrial and guys, to say we're serious about this, because especially international industrialists especially are particularly impressed by the fact that we as a state are forward-looking, and it's important for them.
I'm going to throw this out here, and I'm not sure of your experience if you feel comfortable commenting on this, but in developing your solar generation, do solar facilities avoid any risk when compared to a utility developing their generation plant, whatever generation they choose, whether it's their utility-owned solar or a gas plant or, well, we're not going to see coal plants, I don't think, but any of that.
Sure. So, I mean, the primary, no, we have all the same risks. We just bear it. I mean, that's the thing is we bear all of those same risks that they have. So I would say they have much less risk than us because they're getting paid back for it. We're bearing all of the risks, and they are the same environmental risks, although they don't have things like the interconnection risk that we talked about. They go in understanding that. So we bear much more risk. We bear it on our own balance sheet. And we take that off of the ratepayer. And that's the reality of what we do. But we're willing to do that if we can get a fair return, and the fair return has to make sense given the avoided cost rates. And that's the reality of the world kind of we sit in.
Thank you, Mr.
And
Davis.
just,
you look like you're chomping at
yeah,
the bit.
just one addition to the end of that. I mean, when we're talking, one main difference that I think this commission needs to understand when we're talking about contract tenor and what's appropriate for these projects, what works and what doesn't. I mean, a solar facility is not a 10-year facility. It's not a 15-year facility or 20-year facility. You're talking about projects that are upwards of 30 years, 30 plus. Georgia Power right now is signing contracts for 30 years. They just signed one with Duke Renewables. And so when a utility comes in to build a project, they're not asking for cost recovery certainty for 10 years or 15 years. They're looking for recovery certainty over the lifetime of that asset. And so if it's a natural gas facility, it's risk exposure for the lifetime of that asset to customers. And that distinction is just, I think, paramount for when we're thinking about how these contracts are signed. And, we see some evolution of the market, even in the Southeast, where, mentioned Georgia at 30-year PPAs. Duke is signing 20-year fixed cost 20-year fixed cost PPAs for their CPRE program in North Carolina right now. We won a couple of those projects. South Carolina projects can bid into that, or won one of those projects. So that risk assessment and how you compare it to a utility-owned piece of generation, I mean, that's, I think, central to what the legislator is talking about, fair and equal footing and consideration of risk in these proceedings.
Gentlemen.
Can I just add one more thing as well, just to say, so in Georgia, the tenor is good. So we actually have signed in the teens of 35-year contracts with Georgia Power. So these are being done elsewhere.
In the teens, you mean like
number of projects.
Teens. Okay.
So a fair number of projects. In Alabama, we've got 23-year PPAs. So this is being done in the Southeast.
Gentlemen, thank you. Appreciate your testimony. Thank you, Mr. Chairman.
Thank you. Commissioner Whitfield.
Thank you, Mr. Chairman. Mr. Downey, I'm going to just ask a couple of questions of your colleagues, but I do want to say to you first, thank you for being here. I'm not leaving you out. I come from a background in the private sector for over 20 years before I became a commissioner, so I hear what you're saying and certainly respect where you're coming from. But in my years as a commissioner, I've learned that we operate under the utility regulatory framework, as do our utilities, interveners, ORS, all parties, and it's, of course, our job here at the commission to make sure we do follow the laws of this state. So with that, I'm going to go to Mr. Davis. And Mr. Davis, not wanting to pick a fight like Commissioner Williams said again, but I do want to go back to the exchange between you and Mr. Gissendanner. And I'm trying to kind of hone in on where you agree and maybe where you still don't agree. Okay. But it looks like the two of you reached agreement on your definition of the avoided cost in the PURPA Act of 1978 and Act 62 passed here in South Carolina. I think the way I understand your testimony is that you state that Act 62 pertains to a range of issues. Avoided costs may be one of them, but a range of issues that you hone in on is the expansion of renewable energy generation in South Carolina and utility resource planning. And is that a fair characterization?
Those are definitely two of the changes that I point to.
And so while you all may agree on that definition, I think after your exchange, you still, in your mind, that's the focus, one of the two of the main focuses of Act 62, and you, of course, gave a good overview of that.
Yes, sir. I think that definition is an important piece, but a small piece of the overall act and what it requires.
Anything else you want to focus on or direct in your mind that
As far as what's changed here?
Yes, sir.
Yeah, so you mentioned integrated resource planning, and I've heard you comment on this in
Certainly.
recent proceedings as well, that this is becoming increasingly important across the industry. There are a lot of attention's being paid to how utilities think about their 15-year planning horizon, and Act 62 gives you all a lot of additional discretion and direction and authority over what's actually in those plans, the requirements for considering alternative portfolios, rejecting those plans if they don't meet those standards. And so that really is, and I think it's unfortunate that we weren't able to go through that IRP process prior to this avoided cost process, because avoided cost is so dependent on what those resource plans actually say. So in 2 years, when we come back, I expect we'll be having a different conversation, looking at different assumptions and whatnot. But the commercial industrial program, the community solar program, the ways in which the legislature directs this commission to deal with interconnection, and all of what's written into the avoided cost component of this related to transparency and additional issues like storage and ancillary services and how they need to be treated. And then, we've had, Commissioner Irvin, you've asked a lot about the integration charges and those issues. And I think the legislature clearly contemplated that as being an emerging issue that needs addressing. And they authorized this commission and the ORS to engage in an integration study to look exactly at that type of issue. And those are the types of studies we need that this commission can rely on and that intervening parties can be comfortable with. They've been done objectively in an unbiased way through a stakeholder process, and we're having a conversation that's based on a level playing field rather than an analysis that's done by the utility behind closed doors, and we have limited ability to look under the hood. And so we need to be, just and reasonable means being able to defend it. I don't think the utilities defended it, but certainly that integration study authorized by the Act gives this commission the ability to get there.
In short, the new Act gives, and as it relates to IRPs, gives this commission a tool it's never had before. Is that what you would say?
Yes. Yes, sir.
Well, thank you, Mr. Davis. I'm going to turn to your other colleague, Mr. Burgess, just a minute. Mr. Burgess, I believe you're a little younger than me, but I believe my colleagues up here will tell you your academic pedigree far exceeds mine. So I'm privileged to question you today and ask you a few things to help me see in the future just a little bit. And I think Commissioner Belser even called you Dr. Burgess. So we're glad to have you here today. And I want to ask you, since you've had experience in other states, do you see that an act like Act 62, I want to get your opinion on how this plays out in a state like ours. A lot of you have used the term monopsony in your testimony. And right now, we still operate in the type market that we operate in. How would you say Act 62 would be carried out in a state that's in an RTO state versus a state like ours? What would you describe as some of the differences that you see, how it would be implemented versus a vertically integrated state like ours?
So I'm not a complete expert on everything that's in Act 62, but my understanding and based on some of the issues that my colleague just raised, things like integrated resource planning, those types of issues, I mean, they're not necessarily incompatible with an RTO type of situation, if that's what you're getting at. I know, just in my home state of California, there's a market that's operated, the California Independent System Operator, that's like, the RTOs around the country, but we also do planning, integrated resource planning, and there's legislation that guides that that I think in some ways may be similar to Act 62, trying to do things like promote competition for renewable energy and those sorts of things. So I guess maybe you could sort of clarify a little bit about what you're getting at with the RTO distinction there, but I think that there's certainly ways it could be implemented in an RTO state. Yeah.
Well, I guess, again, none of us have a crystal ball, and Mr. Davis, you feel free to jump in if you want to, but back to my original comment to Mr. Downey, I'm coming from the private sector. I guess what I would say, we know through NARUC and watching other states, there have been stranded assets in some of these other states that are in the RTO states. How can we protect ratepayers in the event that some of these assets do become stranded? How can we make sure that ratepayers, of course, we're still operating in the vertically integrated rules and laws here in the state, I get that, but how can we make sure that ratepayers are protected all the way around?
Right. And so in stranded assets, I assume you're referring to sort of legacy, utility-owned generations that might be taken offline or something like that due to these.
Yes, I'm talking about existing generation that might have years of life of service left that's been taken out of service.
Yeah.
Before its life.
Right. Yeah. I think the very first question to ask is a complete analysis being done on the total cost of those legacy assets versus the new ones? Because what we're finding actually in a lot of places is that the low cost of renewable energy generation is actually lower than even just the operating costs of some of these legacy assets. So you can actually save ratepayers money just through operating costs reductions alone, regardless of any kind of fixed cost that might be associated with a stranded asset. So that's question number one is, regardless of how you treat that stranded asset, can you save ratepayers money on the operating side? Now, once you've looked at that, I think then you get to question of, well, what do we do with the stranded assets? And, there's lots of different ways to approach that problem. That's been done over the years. I mean, it was done back in the 90s with restructuring, but, I think more recently there's been looks at, how do we do potentially, refinancing options. There's lots of tools actually regulators have at their fingertips to try to address these things. And so I wouldn't presume, what this commission should do, but, just an observation that, there are solutions.
Well, right now we're still a vertically integrated state.
Right, even within that environment.
Yes,
I'm saying, you can still have, those types of approaches even within a vertically integrated environment. Yeah.
Yes, sir, Mr. Davis.
Certainly, securitization is one of the topics that's been on the lips of legislators in the Carolinas over the last couple of years as it relates to things like storm cleanup, but also potentially evaluating stranded assets like older coal units. I mean, the North Carolina Utilities Commission just recently ordered Duke in its next IRP to analyze their entire coal fleet for early retirement. And so, it starts with things like the IRP, looking at what the assets are, doing a proper analysis and seeing where there's opportunities for savings and potentially early retirement. But yeah, I mean, absent the market sending those price signals and telling folks what their plant's worth and what their power's worth, you all have a big responsibility in that. And I think IRP is one of the ways to gain the proper insight.
Well, thank you for your answer, Mr. Davis. Securitization has been brought up over here before. And certainly thank you both for your answers, and that's all I have, Mr. Chairman.
Thank you. Commissioner Howard.
A couple questions. Mr. Burgess, in your testimony, you mentioned that eliminating the integration charge would be negligible on a bill. Even though the charge would be minor, charging the customers these costs be fair and reasonable?
So let me clarify. You're asking if the integration charge were implemented, would the cost to customers be reasonable for doing that? Well, I think so the integration charge really in this case is being levied not against, ultimate customers of the utility, but it's really being levied against the QF providers, the developers of the resources themselves. So in that sense, it's really, I don't see it as a charge to customers as much as it is it could reduce potentially, it's meant to offset other charges on the system, integration costs that presumably would be a cost to customers if those.
That was my question. Eventually it would work down to the customer.
Yeah, it would be a potential savings to the customer, I guess, in that sense. The integration charge would be a potential savings to the customer by reducing the QF rate. But I think that sorry, is there a question?
Mr. Chairman, I would ask why Witness Downey is conferring with his attorneys during examination.
First time testifying.
Don't do that anymore.
Go ahead, Mr. Burgess. Mr. Burgess, go ahead.
Our apologies, Mr. Chairman.
As I was saying, though, I think that what we were testing in our analysis was really just what would be the impact of taking that charge out. What is the potential, I guess, what is the potential impact to the overall revenue requirement associated with the QF component, leaving aside whether or not there's actually integration costs on the system that it's offsetting.
Thank you. Mm-hmm. Mr. Downey, a curiosity question. What do you consider when you buy when you buy land, what do you consider? What all goes into your thought process in purchasing a facility site?
So I should clarify, most of the time we sign long-term leases because most of the landowners we deal with want to keep the land in their family, and they're just looking for a way to diversify income away from their normal streams, which we're great with. But we're looking at parcels of land that are close to utility lines that can handle the power that we want to put on those lines. We're typically looking for cleared, dry land. We are in areas that we believe we can get good rates. Typically, we're going out into communities that we've seen depressed kind of lease rates for a long time, and so we can go in and we can give these guys these families multiples of what they've been getting for lease rates. So all of those things to where we can really make a difference in that community with the tax revenues that we bring, and so all of those pieces kind of fit together.
What would be a minimum acreage?
For what we do, probably about 15 acres. And it goes on up from there, but that's roughly. We've done some that were smaller. We've done some that were as small as like 8 or 10, but it's hard to do down, especially in Dominion territory.
Okay, no, just curious. Thank you very much. Appreciate you.
Thank you. Commissioner Williams.
Thank you, Mr. Chairman. I have a couple more questions, gentlemen, I forgot to ask. The concept of fairness came up during you all's testimony, and I know that can be an abstract concept, but based on Act 62, in your opinion, what would it mean for this commission to treat small power producers fairly?
Yeah, well, as you mentioned, I do think there's certainly a subjective component to that. But I think it is when you are looking at contract tenor and how we recover our cost versus how a utility finances its facility and its ability to bring that infrastructure online. That's certainly a component of it. I think in terms of the consideration of expert testimony that we and other interveners submit in this docket, looking obviously you want to evaluate it for credit or for credibility and merit, but taking seriously the alternative analyses that are before you, and not defaulting necessarily to the utility, because in the past these have been kind of utility driven proceedings. So I think at every step of the way there's this consideration of how do you balance risk and customer interest on one side with the options for providing them with the value that comes along with either a utility facility or a facility owned by a small power producer, and that is what the act is getting at. There needs to be an even playing ground there when those considerations are being made.
So is it your position that this commission has historically defaulted to the utilities, the large utilities position?
I think that that's part of the Act 62 is that we're there's an expectation that renewables have a bigger role to play, that small power producers have a bigger role to play in the state, and that additional guidance and requirements directed at this commission were necessary, and that's what they did. I don't mean to suggest that the commission hasn't been doing its job. I think simply there's inertia from a century of doing business in a certain type of way with certain players, and that's changed, and that's reflected in Act 62.
Okay. Thank you for sharing that. Can you provide a real-world example of a successful adoption and implementation of an avoided cost system similar to the one you're suggesting?
Well, I think, as Steve Levitas, Mr. Levitas spoke to earlier, there's been probably limited success of PURPA around the country. It's not been the primary tool, as much attention as it gets in certain circles, and we're about to have this debate at FERC related to the notice of proposed rulemaking. There aren't a lot of states where PURPA drives solar development. North Carolina is certainly probably the exception to that, where they're one of the top solar producing states in the country. That they relied on PURPA as the mechanism for meeting the RPS, the Renewable Portfolio Standard requirements that they adopted and placed on the utilities in that state back in, I think, 2007. And so that would probably be the state where it's been most viable. I don't know. I might defer to John Downey though on other places where we're working, and it's also available. We tend to be involved in a lot of competitive solicitation environments and moved into RTO, ISO type arenas as well.
Yeah, I think that we started in North Carolina. Our first projects were in North Carolina. That obviously is the big one. I think Oregon as well. We're working in Oregon now, and that is PURPA based. I think that there are challenges everywhere. That's just the reality of it, because in these regulated markets, you're always going to have the competing interests and trying to figure out how to make it work. Frankly, I think that you on the commission have an opportunity to point the way, because it's becoming even more and more important in the coming years. So that I'm aware of, I can't. There's nobody that pops to mind and says these guys are doing it great. There isn't somebody out there that I say it's working really well for the utilities and for the developers. So sorry to not have some standard bearer for you, but I think it's really an opportunity for us to get it right.
Okay. Mr. Burgess, you mentioned a zone of reasonableness on page 11 of your direct testimony. Would setting avoided costs at the higher end of your zone of reasonableness require utility companies to set rates above the actual avoided costs incurred?
Not necessarily. I think the whole point of the zone of reasonableness concept is that we don't know exactly what those avoided costs will be 10 years in the future. So, just by the nature of how we calculate these rates, I mean, there's a range of possibilities, right? Nobody can say with 100% certainty what the price of natural gas will be in 5-10 years from now, right? So all the inputs, there's a lot of subjectivity in terms of what inputs get put into these models, and there's a range of possible input options, and so this concept is really meant to portray, that there is that range or that zone of reasonable inputs that could be considered, and so you could consider anywhere within that as being a sort of reasonable option, and could reflect what actual avoided costs will be at that point in the future. But I don't think anybody has a perfect crystal ball to say what that will be, and we have to make, as has been alluded to earlier, we have to make our best judgment, based on what we know today. And there's I think some room for some subjectivity within that, as far as which way do you lean? Do you lean kind of to one end of the range or the other?
In your opinion, does Act 62 encourage customers to pay more than the actual avoided costs?
I don't have any reason to believe that, although again, I'm not an expert on every word of Act 62.
Gentlemen, did you want to answer that question as well? That was my last question.
I'd say that it doesn't. I think that's what we're trying to do, as Mr. Burgess referenced, is there's a deciding on the reasonable approach, reasonable inputs that compute an avoided cost rate that inevitably is not perfect, but certainly the goal is accuracy.
That's all for me. Thank you, Mr. Chairman. Thank you, gentlemen.
Thank you. Any other questions, commissioners? Gentlemen, I've got, I appreciate the, you telling us, talking about the short timing, the hurriedness of all of this. We've certainly felt that. I've got, and it's, well, the questions I have, and I need some help here. Most of the questions that I did have get asked early on, but I come, if you know my background or if you don't, I come from a small city where we were an electric provider, and at my house, I get 86% of my power from a nuclear plant, 4% from a hydro, and 10% off the market. So that's the place I operated from for a long time. I need some help and some comfort. We as we get into these discussions, we start talking about all, I worry about capacity factors. That's my training and upbringing. So I need some help in making me comfortable when we talk about we start talking about base load power, capacity factors of 94% and up, or ramping up peakers that can ramp up fast, as opposed to then we start talking, when we're talking about some of the prices of, say, natural gas, other things going up, being volatile, and how something with 17%, 20% capacity factor, we talk about them in sort of the same mishmash of talk, and so that's where I'm trying to get my brain around and be comfy with everything we're talking about. And I figured, this panel looks like you could probably help me there. So, and Mr. Davis, you've talked with us a lot of times, so I'll throw that to you first. And if that whole line of sentences made any sense.
I think I understand exactly where you're coming from, and this is the challenge of the 21st century energy landscape.
Exactly,
right?
And that's why I'm trying to get help. Get a little help here.
These are new technologies, and how they fit within a broader portfolio is part of what we're doing here, is understanding what value actually is provided from a capacity standpoint. So it's when you look at a 100 megawatt solar farm, it's not assumed to be 100 megawatts of available capacity there all the time. You're only getting paid for that portion of capacity that's available, useful. Same with energy. You're being paid for when it's delivered, not the prospect that it might be. And to technologies like storage are now competitive. There were 2 projects in the Norcana Duke CPRE competitive solicitation that had solar plus storage as part of them. So, I mean, in real time in the Carolinas, you're seeing competitive solicitations deliver that type of technology. Heard a little bit about flexible solar and dispatchable solar PPAs. That's an idea that's certainly gaining traction. There's a good study out of Tampa Electric that looked at that. We referenced that in our expert testimony and the idea that we should be contemplating those as a state, probably doing some stakeholder work around those and figuring out what that would look like. It gives the utility additional flexibility to ramp up and ramp down, follow load in a more specific way. So there's value that can come with it, as well as for things like ancillary services generally that can be provided by solar. So it is, solar is a piece of the broader utility portfolio, and storage will be part of that, and maybe there are resources that we're not thinking about that will be part of it. But maintaining flexibility with whether it's rate design or being diligent in our resource planning, thinking about what's ahead and changing when the changes actually arrive, that's going to deliver the flexibility and the value that we're trying to accomplish here.
Thank you. Anybody else want to weigh in on that?
I can add, I think just as a general thought, I think that, yeah, I mean, these sort of traditional notions of, base load, intermediate, peaker, I mean, those are kind of the old definitions of how we used to think about and plan for the system. But in many ways, we're moving past those definitions and, seeing that they're not applicable to the future of the power industry, and we're thinking more about things like flexibility as being a very premium type of service that we need to find, and how do we think about reliability services versus kind of the old definitions, and what is truly needed technically on the system versus these kind of heuristics that we've had up until now. I mean, even things like base load power, right? I mean, you've got your nuclear fleet, your coal fleet, that operate, typically had operated as base load, and now, those can be actually some of the sources of these costs that we're talking about, integration costs, because you're not able to ramp those units up and down, and they're actually, can be a burden on the system when you start to bring in variable resources like solar and wind and other things. So, really, it's a paradigm shift, but it's one that we're learning lots about. There's lots of great analyses and studies are being done by our national labs, by other entities, utilities are doing great work on this to try to figure it out. And I think that it's important, I think, just to not get too hung up on some of these older traditional notions of things like capacity factor, because that's evolving too, and we really need to think about the whole cost of the system and how everything fits together, looking at it on a portfolio basis rather than just on an individual plant level. So,
Thank you. Okay. Well, I know that one of the things we're doing with this commission is research, and we've got folks that are working on looking ahead, so we can be a little more ahead of instead of reacting. So, and that's one of the things I applaud all of my colleagues for is doing that a lot. Commissioners, any other questions? Mr. Adams, any redirect?
No, sir, Mr. Chairman, no redirect.
Thank you. Gentlemen, thank you for your testimony. Thank you for being here, and you may step down and you are excused.
Thank you, Commissioners.
thank you.
Okay. We're going to take a break for lunch, and I would like for everyone to be back here at 12:56, 12:56. Let's see if you can get out and get something to eat by then. 1:56.
Mr. Stenslick, if you would raise your right hand, please. Do you solemnly affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth? Thank you.
Thank you. Ms. Bowen, welcome. Make sure you get that microphone on.
Let me make sure I got it there.
There you go.
Thank you, Mr. Chairman. Mr. Stenslick, please state your name and business address for the record.
Derek Stenslick, and my business address is 475 Broadway, Unit 6, Saratoga Springs, New York, 12866.
Thank you. And Mr. Stenslick, did you cause to be pre-filed in this docket on September 23rd, 2019, direct testimony consisting of 11 pages and 2 exhibits to that testimony?
Yes, I did.
Do you have any changes or corrections to your pre-filed direct testimony at this time?
No.
If the questions were put to you in your testimony were asked at the hearing today, would your answers be the same?
Yes.
Were the exhibits to your testimony prepared by you or at your direction?
Yes.
Mr. Chairman, I would now move to have Mr. Stenslick's pre-filed direct testimony entered into the record as if given orally from the stand, and to have the exhibits attached to his pre-filed direct testimony identified as pre-marked exhibits A and B.
Okay, Mr. Stenslick's pre-filed direct testimony will be entered into the record as though given orally from the stand, and his exhibits, you said A and B?
Yes, sir.
A and B will be entered as exhibit number 12.
Thank you. Mr. Stenslick, did you prepare a summary of your direct testimony today?
Yes.
Would you please give that to the commission now?
The purpose of my direct testimony in this proceeding was to review and evaluate Dominion's proposed variable integration charge. In that, I discussed with the methodology used to develop the proposed VIC and recommend that the commission reject the charge as unsupported and inappropriate at this time. The basic premise that adding variable renewable generation to the power system may increase some aspects of operating costs is not unreasonable. The use of hourly production cost modeling and comparing cases with and without additional solar generation is also generally accepted by the industry. However, Dominion's analysis incorrectly analyzes solar data and therefore overstates the associated utility reserve requirements. Until these problems are addressed, the cost of variable integration will be overstated. In my pre-filed testimony and the attached exhibits, I cover many of the details supporting this position, including the following 4 main points. First, there were limitations with the assumptions. The analysis failed to adequately account for aggregation benefits that naturally reduce the relative forecasting errors and resource variability as the solar generation fleet grows. While 4 sites were evaluated in the study, actual solar generation will be spread across dozens or hundreds of solar plants. The analysis also used an excessive 4-hour ahead forecast, overstating the forecast error that may impact actual operations. The 4-hour ahead solar forecast error also did not include offline combined cycle generation capacity as available reserves. Finally, the operating reserve methodology used an overly stringent 99% confidence interval, covering all but 1% of solar forecast errors, which overstates the required operating reserves. Second, there are several concerns with the modeling methodology implemented in the study. Most troubling is that the additional fixed solar reserve requirements were imposed 8,760 hours a year rather than being a function of the hourly forecasted solar generation, greatly overstating additional reserve costs. In addition, neighboring power systems were not properly accounted for in the analysis, thereby eliminating an economic resource regularly utilized by Dominion. This omission greatly overstates additional reserve costs. Third, Dominion failed to evaluate less costly methods of integrating low-cost renewable resources. For example, Dominion failed to evaluate the full range of services that could be provided by new battery energy storage, thereby overstating the cost to implement those resources as a mitigation option. Lastly, Dominion did not evaluate the potential to reduce ratepayer costs through participation in a larger balancing area or by implementing new demand response, flexible solar, combined cycle upgrades, and discounting of solar forecasts. Fourth, variable integration charges targeted at a specific technology are fundamentally flawed. No single technology should be singled out for integration charges because the system operates as a whole. Each generation technology has limitations, and the system should be optimized to deliver least cost service to ratepayers overall, rather than developing individualized charges that are only applied to a subset of generation resources. The study and charge as proposed indicate that Dominion may be seeking an approach to integrating renewables that will ultimately impose unnecessary and excessive fuel and reserve costs on an ongoing basis. Given the significant problems with the study, approach, and the analysis, the Commission should not approve Dominion's proposed variable integration charge. The utility should revise its approach to address the problems identified and hold off any integration charge until these concerns have been addressed and the utility has gained more operational experience so that actual charges are not based solely on flawed simulations. To remedy the limitations in this study, Dominion should reanalyze the proposed variable integration study. A good opportunity for this is the grid integration study set forth in the South Carolina Energy Freedom Act, or Act 62, which authorizes an independent study to evaluate the integration of renewable energy and emerging energy technologies into the electric grid. This independent study process would serve as an improved starting point for beginning to evaluate variable integration costs as they relate to other grid integration topics, including the benefits of integrating increased renewables and emerging energy technologies like battery storage. In doing so, Dominion should also consider utilizing a technical review committee composed of outside experts on variable renewable integration.
Thank you, Mr. Stenslick. Did you also cause to be pre-filed in this docket on October 11th, 2019, rebuttal testimony consisting of 19 pages?
Yes, and I'll apologize for the length, but...
Oh, and just a moment, Mr. Stenslick. Do you have any changes or corrections to your pre-filed rebuttal testimony at this time?
No, I do not.
Okay, and if the questions put to you in your rebuttal testimony were asked of you at the hearing today, would your answers be the same?
Yes.
Okay, and Mr. Chairman, at this time, I would move to have Mr. Stenslick's pre-filed rebuttal testimony entered into the record as though given orally from the stand.
Mr. Stenslick's pre-filed rebuttal testimony will be entered into the record as though given orally from the stand.
Thank you, Mr. Chairman. And Mr. Stenslick, have you also prepared a summary of your rebuttal testimony today?
Yes, I have.
Okay, thank you. And would you please give that summary to the Commission now?
Yes. In my rebuttal testimony, I respond to Dominion witnesses' rebuttal to my direct testimony. My testimony makes clear that I did not advocate for an abandonment of all operating reserves. I understand there may be a need for and the importance of operating reserves to integrate wind and solar. However, I also understand the monetary and environmental costs associated with overly conservative reserve requirements and requirements based on imprecise assumptions. There's often a trade-off between additional reliability and economic efficiency, which must be appropriately balanced. Overly stringent reserve requirements lead to unnecessary operating costs with only marginal or no benefits to overall reliability. Statements filed in the company's rebuttal testimony seem to characterize my testimony as recommending that Dominion shift their reliability responsibilities to neighboring utilities. I want to clearly articulate that my testimony does not advocate a shift of risk to neighboring utilities, a desire for Dominion to ride the lines of the Eastern Interconnect, or ignore the importance of NERC standards. Rather, my testimony correctly identified allowable operations within the NERC standards and identified the benefits of a large interconnected grid. It also clearly advocated for a coordinated approach to managing solar variability with neighboring balancing areas. There are 4 points I would like to make regarding neighboring utilities and NERC reliability standards discussed throughout Dominion's witnesses' rebuttal testimony. 1, Dominion is not an electrical island. It is interconnected with many neighboring utilities and balancing areas. Electricity can and does flow regularly between these. Dominion can and regularly does contract with neighboring entities for energy supply and reserves. Modeling the Dominion grid in isolation, as evaluated in the variable integration study, removes a highly economic form of system flexibility and ignores an important mitigation for solar integration, which has been clearly identified and implemented by other utilities around the world for many years. 2, NERC reliability standards recognize that perfect balancing of interchange with neighboring balancing areas is neither possible, expected, nor necessary. These requirements allow for some level of short-term inadvertent flows between utilities. Assuming that Dominion must immediately cover 99% of all solar forecast errors, and to do so locally is simply not true. A short-term change in area control error for very rare forecast errors can be corrected without burdening neighboring balancing areas or threatening reliability. This amount of reserves is overly stringent and would add undue cost to integrating solar power onto the grid. 3, neighboring balancing areas are an asset, not a liability. My testimony did not advocate Dominion to push their challenges onto their neighbors, but rather to coordinate with them further. Other neighboring utilities are undergoing the same changes on their system and are challenged with solar variability and uncertainty. It would be far more economic and in the ratepayers' best interest to tackle these challenges collectively rather than independently. When spread over large areas and multiple balancing areas, solar variability and uncertainty is significantly reduced, and a larger pool of reserve assets become available. There's a long history and precedence for this type of coordination. Today, there are many contingency reserve sharing groups across the country, including VACAR, which Dominion is a member of. In addition, the foundational element of ISOs and RTOs is the recognition that pooling of resources and reserves is more economic. California ISO recently implemented the Energy Imbalance Market, which combines participation across both vertically integrated utilities and deregulated utilities as their primary tool for integration of renewable energy. Reserve sharing and coordination is the economically responsible behavior for the ratepayer, regardless of the market structure. While this type of coordination will undoubtedly take time to develop, it is certainly reasonable during the long-term study horizon evaluated. I will add that this coordination does not necessarily require a reserve sharing agreement. By simply increasing bilateral energy transactions with neighboring utilities, Dominion can free up their own generation, allowing their generators to back down to lower loading levels to provide reserves instead of energy. There's already a long history of these energy transactions, and it is a regular part of Dominion's operations. This mitigation could be introduced today. 4. Finally, my testimony did not diminish the value of reliability to Dominion's ratepayers or ignore NERC reliability standards. Rather, the Dominion witness misunderstood my comments stating that the loss of solar generation would not pose a reliability challenge. I discussed that under the levels of solar penetration evaluated by Dominion, a grid-wide blackout and loss of load is extremely unlikely, even if all the solar were to drop off the system simultaneously. This discussion in my original testimony was used to characterize the risk associated with reserve shortfalls. Rather than a grid outage event and customer disruption, a shortfall could lead to a potential violation of NERC standards and a potential fine. This is an important distinction when evaluating the trade-off between risks and costs associated with reserve requirements. It is important that regulators and ratepayers properly understand the level of risk associated with the grid planning decisions so that they can appropriately balance trade-offs between reliability and costs. In addition, I'd like to summarize my rebuttal testimony addressing certain points raised by Dr. Tanner. In particular, it is worth noting that changes to inputs and assumptions that may appear to be relatively minor and technical, things like geographic diversity, confidence intervals, and hourly reserve requirements, can actually lead to a large change in costs ultimately borne by the Dominion ratepayers or passed through to independent power producers. It is important that Dominion perform the analysis well and involve key stakeholders and independent review before imposing these increased costs on solar projects, which has an ultimate impact on the Dominion ratepayers. For example, Dr. Tanner in his rebuttal testimony states in his rebuttal testimony that he appropriately analyzed geographic diversity in his study. While the importance of geographic diversity was acknowledged in the study, the analysis did not go far enough. Rather, it evaluated geographic diversity for solar forecasts across only 4 sites in the Dominion service territory. In reality, solar will be developed across dozens of sites and thousands of rooftops. I agree with Dr. Tanner's conclusion that it is critical to incorporate geographic diversity in an integration cost study because it has the effect of reducing the total amount of uncertainty faced by Dominion. Without considering geographic diversity, the estimated integration costs would be too high. However, his analysis did not go far enough. Additional geographic diversity should be included to represent the spatial diversity of solar installations on Dominion's system. Another example is Dr. Tanner's assertion that using a static solar reserve requirement across even nighttime hours is appropriate. This statement is not true and highly misleading. For example, Dr. Tanner's testimony included a chart showing reserve shortfall events before 9 a.m. and after 6 p.m., which would constitute low or zero solar output. These time periods would require no additional solar reserves. This is especially true in the winter when the system's most challenging operations occur during early morning load ramp and evening peak outside of daylight hours. However, these hours were evaluated by Dr. Tanner with the same amount of reserves as midday hours. The blending method suggested by Dr. Tanner to account for this is not standard in industry practice. Production cost modeling tools such as GE Maps and Plexus have been used for many, if not most, of North America's largest variable renewable integration studies and are capable of simulating hourly reserve requirements. Hourly simulation of reserve requirements is a standard approach implemented in renewable integration studies, and the cost of variable integration studies should be no different. Finally, Dr. Tanner asserts that his study correctly evaluated other technologies for providing reserves. However, the testimony states that the resources were evaluated solely to provide reserves. A battery storage asset or other new technologies can provide multiple benefits to the system and should be evaluated in a more holistic way. These services could include firm capacity benefits, energy or energy arbitrage benefits, transmission and distribution deferral, and environmental benefits. Evaluating only the reserve provision limits the ability for the resources to be economic based on multiple value streams. In my pre-filed testimony, I discussed additional details regarding assumptions and data that should be reanalyzed in the variable integration cost study. I'm happy to discuss any of these points further today. This concludes the summary of my filed testimony.
Thank you, Mr. Stenslick. Mr. Chairman, before I make the witness available for cross, one preliminary matter. Yesterday, Dominion introduced a revised exhibit for witness Hanslick, and I've asked Mr. Stenslick to take a look at that revised exhibit in case he has any brief response to that. If the commission would allow it, I would appreciate that. Okay, thank you, and I'll use the Elmo if that's all right.
Yes, sir. Get that microphone, Mr. Ziegler.
The only revision on that exhibit was to change the date and to change the load curve, which that had the load curve, the orange line at the very top was not the right one. So if Mr. Stenslick wants to comment on the date or the orange load curve, perhaps he has a point, but if he wants to comment on anything else, he's simply adding to the testimony, and we will not have a chance to respond to it.
And Mr. Chairman, if I may respond. If Mr. Stenslick, I know you responded to the initial graphs, not the revised graphs, but the initial graphs in your rebuttal, in your surrebuttal testimony. So, as Mr. Hanslick did yesterday, what I would ask is if you would keep it to a summary and respond to the graph as it's now been provided and consistent with your surrebuttal testimony in line with what was done yesterday. I would appreciate that.
Mr. Chairman, Mr. Hanslick pointed out that nothing has changed on this graph. This is exactly the graph that was included in his testimony. So there's been no amendment to that slide whatsoever. This is simply an attempt to inject testimony into the record that's not been pre-filed.
If I may, we are in favor of providing additional information to the commission, but consistent with the testimony and summarizing it and responding to what is new, which there are several things new here. And I think it's within the commission's ability to determine what's relevant and not, and outside of the scope of the testimony pre-filed in this proceeding. But I would ask for the opportunity for a brief response.
There's nothing new here. This is exactly what was in the pre-filed testimony. The only thing that's changed is they added the labels to the megawatts, so you don't have to go over to the side to read the numbers. But it's exactly the chart that was made available as required in the rebuttal testimony of Mr. Hanslick.
So the load curve was not changed, nothing.
On the slide, no, sir. Nothing was changed except the adding of those labels showing the megawatts. And they're the same megawatts you'd get if you put a ruler on it and went over to the sides to determine what that was.
Aren't there additional hours on that? The times across the bottom axis are different than what was in the testimony, are they not?
I'd have to go back and look. It's not different data. It's just maybe more detail in the scale, but it's the same data that's always been there.
Alternatively, Mr. Chairman, I would say Mr. Stenslick could just refer to this as needed in responding to commissioner questions. That would be another way to do this if we're going to draw this objection from Dominion. We just want to be able to provide full information for the commission's benefit.
Okay, let's do that then. That's fine.
So I'll just leave it up there in case he needs to refer to it. Thank you so much.
Okay. Cross-examination.
No questions.
Okay. Any other parties? Commissioners. Commissioner Belser.
Good afternoon, Mr. Sindley.
Good afternoon.
I wanna go through, your analysis somewhat, and there were just some, you've mentioned some points, I may talk to you about those, but, right, I've already lost my place here. Well, let's just start back. You're pretty critical of Dominion's, use and analysis of their solar data. Would that be a fair characterization? And you noted several places where they incorrectly analyze it and resulting in what you've characterized as overstating utility reserve requirements.
That's correct.
Flesh that out a little bit more for me, would you? I noted that you had about four or five points on that, but.
Sure, I'll try to remember to the best of my ability. So one is the geographic diversity, and I touched on that in the summary. And Dr. Tanner used 4 sites to illustrate that geographic diversity.
Well, let me add something to that. Dominion serves, South Carolina's a relatively small state. Would you agree with that?
It is.
Okay. And Dominion would serve over in the western part in Aiken and over to the Midlands here in Columbia and down to Charleston and I think down into Beaufort too. So from here to Charleston's what, 120 miles? And then Beaufort's probably another 60 or 70 below that. And then up, you know, from Aiken to Columbia is probably, what, 60 miles. So is that really geographically diverse?
Yeah, there's 2 ways I'd address that. So one is that what we're concerned here is sudden drops in solar output. And the only geographic diversity you need to cover that, it's a passing cloud. And so even within one solar plant, as that cloud passes over the panels, you'll see the power production from individual panels drop. And so when you start to expand that out, you look at the shadows cast by the clouds, that's over fairly small areas, right? And so by expanding the geographic footprint, we're not worried about it being overall a cloudy day across all of South Carolina. What we're worried about is the clouds passing all over these solar facilities, which may only be for 15 minutes in a pretty tight time frame. And I would add that when you get events that are kind of shown in this chart here, where the solar is dropping off, that can be from, you know, one plant, and it could be a front coming across the state, like a weather front coming across the state of thunderstorms. And what you'll see is that when you start to aggregate multiple plants, the overall variability will decrease and so will the uncertainty. So even across 2 plants that may only be 10 miles apart, when you're looking at that short-term fluctuation, you can see quite a bit of difference at the short-term level.
So how does that fit into your assertion that it overstates the reserves?
Right. So the reserves were evaluated all of the solar uncertainty, so the mismatch between the forecast data and what actually showed up, right? And so the difference between that green line and the blue line, right? So it's looking at those deltas. And specifically, it's carrying reserves to cover 99% of all of those forecast errors. And so when we look at the reserve requirements, it's being held by the most extreme events, right? That's what's holding the reserve requirement across the entire year, even the nighttime hours. And so just a few outliers of that top 1% of hours is really what's driving the required reserves and ultimately leading to higher cost. And so if you can just trim off some of that uncertainty, then you could dramatically reduce the overall reserve requirement.
When you say trim off some of that uncertainty, tell me what you mean by that.
Yep. So if you were to, the probability or the chance of the solar dropping out simultaneously across multiple plants spread out across the state, even though it is a small geographic footprint, the probability of those drops all occurring at the same time is very low. This chart is showing probably one of the worst days they've had over the past several months. But it's also only showing 300 megawatts of what they had kind of installed and operating at that time. When you increase this to 1,000 megawatts or 2,000 megawatts spread out, you're just going to, the more assets that you bring on, the chance of all of that dropping off at the exact same time is diminished, or even across, several hours.
I was, one of the sentences in your testimony or ideas in your testimony and in your study was that imposing 8,760 hours per year in calculating solar reserves. Is that a fair characterization of how you've stated that number?
That was a critique against what was being proposed, yes. Okay.
And 8,760 hours equates to?
Every hour of the year, so even the nighttime hours.
So what do you think is the proper way? How many hours or what periods of the day do you think is the proper way to use that to calculate?
Good question. So what I would say is the proper way to address that is, first of all, limit the solar reserves, which again, we're carrying these for the chance that the solar drops off unexpectedly. So carry those reserves only during daylight hours, because we know for certain that overnight there's going to be no solar variability or uncertainty. So we know that with certainty. So the first recommendation would be only apply those to daylight hours. The second recommendation is to do it based on what you're likely to expect at each hour. So we know the morning hours, as you can see from the green and blue line on the chart here, we know the solar output will be much lower than the afternoon hours. So the chance of the solar dropping, in this example, by 300 megawatts at 9 a.m. or 10 a.m. is non-existent. We know that's not going to happen just because the sun isn't high enough in the sky for that. So what I would recommend is that for each hour of the day, you would look at what is the forecasted solar and set your reserve requirement based on what that forecast is saying.
Do you have a number of hours that would appropriately capture what you're talking about as far as daylight hours?
It'd be about 4,000, 4,200, I think. And again, some of those hours would still be much lower than a middle of the day hour as well.
You also indicated that the 4-hour ahead solar forecast era did not include combined cycle generation capacity as available reserves. Could you explain that to me?
Yes. So there's 2 points to bring up here. One is that we did file information requests and did get confirmation that some of the combined cycles on Dominion's fleet can turn on faster than 4 hours. So what that means and again, looking at this chart where you're watching the solar drop off over the course of the day, this is occurring over several hours, 6 or 7 hours. This is not a fast event. This is slow moving over the course of the entire day. So making sure that you are looking at assets that can turn on and respond to that. In the middle of the day, as you see solar dropping, you have more flexibility the longer you look at that time horizon. So within 4 hours, you're still able to turn on some of those combined cycles, and even down to potentially 2 hours. Did that answer?
I think so. But as far as available reserves, what should be included in that calculation are any assets which can be ramped up fairly quickly?
Yeah, so there would be two potential ways to address this. One is to look at changing the forecast to 2 hours, which the closer you get your forecast, the more accurate it will be. So you'll have less drop-offs like you're seeing here on the screen. So that's one option, is just to make that forecast closer. And in reality, what you could do as a system operator is routinely update that forecast, right? So when it's dropping off, you're not stuck with what you were forecasting earlier in the day. You're taking that new information into account. So one way to address that is to shorten the forecast. The other way, if you can't, I think there was a limitation in the data that from NREL that it's a 4-hour ahead forecast that's available. So the other way to evaluate that in the study is to account for resources that can start within 4 hours, which would be some of the combined cycle capacity.
You characterized this next point as most troubling, having to do that additional fixed solar reserve requirements were, and that goes back to the hours.
Correct.
And I think we've, and in your opinion, that, I think the term you used was greatly overstated?
Yes.
Additional reserves. With regard to the balancing area, how can a utility, or can a utility, how do they increase their balancing area? Are those not set?
That would be working and participating with neighboring utilities, neighboring balancing areas, and coordinating with them. So it would be some form of negotiation, working with neighboring utilities. And there's a way to do that through a reserve sharing group, similar to what's in VACAR. They can share some of these reserves that are being held for the solar variability and uncertainty. They can carry that across a much larger area. Because again, going back to the geographic diversity discussion, now when you're looking at across the southeast United States, the chance of losing all of the solar at the same time is greatly reduced over that large of a footprint. And so they can work with the neighboring utilities that are struggling with the same challenge. And again, the chances of you losing assets simultaneously across a much larger footprint is reduced. So that's one way, is to kind of negotiate with other neighboring utilities that are having the same challenges. The other way would be to, you don't necessarily have to share the reserves. You could simply purchase more energy at times when you need reserves. And what that would do is, if you make a purchase for energy, that allows one of your generators to back down and then provide the reserves here locally in South Carolina.
Thank you very much. Appreciate your patience with me.
No, thank you.
Commissioner Williams.
Thank you, Mr. Chairman. Good afternoon, sir.
Good afternoon.
Just a couple of questions for you. In your direct testimony on page 33 of 50, that according to NERC BAL-001-2, a balancing area has 30 minutes to correct for any imbalance before there is a violation. Yesterday, we heard from Mr. Hanslick that Dominion needs to be concerned with the 1-minute score. Specifically, he noted there's a standard where we get a score every minute based on whether we're helping the interconnection frequency or hurting the interconnection frequency. That's transcript page 53, lines 8 through 11. I believe that Mr. Hanslick used this fact to support the use of a shorter period for resolving energy imbalances. Can you explain these apparent differences?
Yes, so there's two items here. One is the NERC BAL requirement that you referred to, which allows 30 minutes before that inadvertent flow becomes a problem. The other is the CPS score that Mr. Hanslick was referring to. And so that is constantly being tracked, and the utility is getting scored on that. But again, it's something that gets averaged over an entire year. So we're talking about, every minute of the year, there being a score. And what my suggestion or my recommendation would be, it's okay to, for the very rare moments, again, these reserves are based on the most extreme events occurring. So if there's a few minutes or up to 30 minutes where they end up leaning on a neighboring utility, that score will get averaged across an entire year of operation. And so again, it's not something I would recommend or to be standard practice, but it's something that's there and it's available as a mitigation. So frankly, not 100% or even 99% of all solar uncertainty has to be managed locally and in real time. There's a little bit of time to react.
Okay. In addition to his rebuttal testimony, Mr. Hanslick, on page 13, lines 9 through 20, notes that the NERC BAL-002 reliability standard requires a BA to restore the system or the system area control error to 0 within 15 minutes. Can you reconcile this with your earlier statement about 30 minutes to correct imbalances?
I would have to double check that and subject to check.
Okay. Is there a difference between NERC BAL 001 and 002?
Yes, there is.
Okay. Can you summarize from your perspective what this means for the variable integration charge analysis that Dominion prepared?
Yes, so BAL 001 refers to kind of normal balancing of power in real time from minute to minute, hour to hour, and making sure that's being balanced. BAL 002 is during a contingency event or an emergency event on the grid. So if a generator trips offline, making sure that you're able to respond to that in time and get the area control area between the utilities back in check after an emergency event.
Okay. You previously worked for GE Energy Consulting and were responsible for the renewable integration practice, right?
Correct.
And you also oversaw a number of renewable energy integration studies in that capacity, right?
Correct.
What was the geographic scope of the balancing areas used for these studies?
It depends on each utility, right? So there, some balancing areas are rather small. I do a lot of work on island systems, which obviously are their own balancing area, and they have no ability for interchange with neighboring. So I've done a lot of work in Hawaii. So that's an example of a small footprint. I've done work maybe most similar to the Dominion example would be Colorado Springs Utilities, which is a small sub-balancing area within Colorado that manages their balancing locally, but then can also work with the larger WACM, what that acronym is for. But when we did that study, we looked at the cost of integrating solar there and determined, we looked at 3 options. One was battery storage, one was purchasing reserves and coordinating with the larger BA, and the third option was spinning reserves from their local gas fleet. And we found in that study that coordinating with the larger balancing area was most economic.
Let me ask you this, how many of those studies were for individual utilities?
I would say about half of them were for individual utilities. The other half were for larger system studies. So one was like a pan-Canadian, which looked across Canada. Some were for ISOs that involved larger.
What was the scope of the balancing areas?
For which, sorry, can you repeat that?
Scope for the studies for the individual utilities, what was the scope of the balancing area?
So whenever we modeled an individual utility, like modeling Saskatchewan, SAS Power in Canada, same with Nova Scotia Power, we always modeled some representation of flows with the neighboring balancing areas. So that's what's important. It's not necessarily the size of the balancing area, but it's the ability to purchase energy from the neighboring utilities.
And so consideration was given to interconnections with adjacent utilities?
Correct.
Okay. And how, could you just explain a little bit more how all this was done given the NERC standards?
So in those studies, we didn't evaluate the NERC standards specifically, but we looked at, there were rules about how dynamically those flows could be adjusted. So at times we would lock in the flows ahead of time, and that's the way you would address this, is say you could show that flows can't increase after the day-ahead schedule is set. So that's ways we were able to identify that. Obviously, the more flexibility you allow those flows, the less integration costs you'll have and the less challenges. But one way to address the NERC standards is to lock in the flows between utilities using a day-ahead schedule or 4-hour-ahead schedule. And then you say after that, to respond to local conditions, you do that using utility assets.
Thank you, sir.
Welcome.
Commissioner, I think Commissioner Howard was next. Commissioner Howard.
Thank you, Mr. Chairman. Good afternoon.
Good afternoon.
You mentioned a while ago, and you also mentioned it in your testimony about the Hawaiian Electric Company
Yes, I did.
and their procurement of grid services, including fast frequency response, regulation services, quick start reserves. You did it through a combination of customer-sited demand response systems, standalone battery energy storage, hybrid solar and storage plants. And they're required to be 100% by 2045. Do you agree that it's possible for them to reach this goal without utilizing the measures you mentioned?
Certainly in Hawaii, they will have to use every mitigation they can possibly implement to get there. As an islanded system, there's more challenges there because they can't rely on flows from neighboring utilities. They're also land constrained and of the sorts. And on top of that, managing load and supply has to be done in a much tighter band than it does here. And the reason for that is if they have a mismatch between their generation and their load, even for a very short period of time, it could lead to a cascading blackout very quickly. It's a low inertia system, and because it's an island, the same challenge is not true of a large mainland utility.
Bring me to a curiosity question. Do you have any idea what the generation mix would be in 2045 or what they anticipate for the generation mix to be?
Yeah, we look at that quite a bit. I'm still actively supporting work being done in Hawaii. There, it's going to be predominantly solar, but they also recognize that they can't get to 100% with just solar. So currently, I'll kind of use Oahu to give you, which is one of the islands in Hawaii, to give you a representative mix. So right now they have about 100 megawatt. It's a 1,000 megawatt peak load system or midday system, and so they have 100 megawatts of wind installed, 500 megawatts of distributed rooftop solar, 150 megawatts of utility scale solar, and another 150 megawatts of solar plus storage coming online shortly. So you look at that, it's going to be over 700 megawatts of solar on a 1,000 megawatt peak system with wind on top of that. So they're pretty far along on the solar trajectory. Plans for a lot more solar going in there, just because pushback they've had on wind. But other islands also have geothermal resources, which they can tap into. A couple of them have some small hydro. But there's a recognition that going from 80 or 90% renewable up to the 100 is going to require some creative thinking. And so right now they've filled that gap with biomass or biodiesel, but I think they're opening the door to making sure they have options available later.
Good. That's curious. Since Dominion doesn't have a 100% renewable goal, what of these measures would they use, or how much would they use of any of it?
Certainly the solar, as the utilities asserted, the solar is already challenging their system operations according to them, and there are mitigations available rather than just cycling up and down their plans. And so I think prudent practice would be to start integrating those mitigations as soon as possible. That would be prudent for the ratepayer. And then as more and more solar comes on, it's going to be increasingly important to look at kind of this diverse set of mitigations, whether it's coordination with neighbors, demand response, battery storage. Those will become flexible solar. Those will become more important.
Utilizing your measures, how much would it cost the average residential customer to implement all these?
To implement all of that? I don't have that number. Some of them, it's important, could be done at lower cost than potentially, when you look at the system as a whole, than today's system. So that's important. When I discuss about potentially purchasing energy from a neighboring utility, that would only necessarily have to be done during these rare events, right? It's not something that you'd have to rely on all the time. Other mitigations like demand response could certainly, especially as the technology progresses, but even today there's opportunities for more demand response, and I believe economically on the system.
Well, I agree with you. This is a very unique situation, and so basically my question is a curiosity. What is the average retail customer pay a month now, and what do you estimate that to be in 2045?
Is that here or in Hawaii?
Here, in Hawaii. No, Hawaii.
I wish I had that answer. I actually don't have the South Carolina rates in front of me.
No, I was talking about Hawaii.
In Hawaii.
Oh, yeah. Mm-hmm.
So in Hawaii, it's the highest electricity prices in the country today and historically, and that's because they burn oil-fired generation for most of their generation. So right now they're at, I believe, right around 30 cents a kilowatt hour. And so when you look at those prices, solar, wind, everything comes in much lower price. Even solar plus storage is coming in significantly lower than today's oil-fired generation.
You have an estimate, rough 20 cents to 18 cents?
Yeah, that's where the solar and storage is coming in today.
But I mean, in 2045, what would you guess would be there?
Yeah, I don't have that answer offhand. Subject to check.
Probably no one else does.
I know that the utility planning is projecting lower retail prices because they're getting off of.
Well, thank you very much. I enjoyed
You're welcome.
testimony.
Thank you. You could have told him anything, he'd have believed. Commissioner Whitfield.
Thank you, Mr. Chairman. Good afternoon, Mr. Stancic. Thank you for being here.
Thank you for having me.
You've obviously had a lot to contribute, but I want to ask you a few questions back to where Chairman Randall was going just before lunch about backstand reserves and also about renewables. And I'm going to try to ask you the same question to each. But I want to just kind of mention to you that this commission, for what you may or may not know, has been under a lot the last couple of years and been called a lot of things, been accused of a lot of things. But one thing that we have not faulted in is reliability. Since I've been a commissioner, I only know of one time, and it's referenced today earlier, the polar vortex, where it was even threatened, and that was handled through a controlled load shedding incident that's been described earlier in this case. So the commission still has that charge of reliability. So I want to talk to you just a little bit about reliability, about backstand and renewables. And in going through your rebuttal testimony, I also want to kind of, at the end of it, see where you agree and where you might disagree with Dr. Tanner, as I did with the panel before, and find some common ground and maybe some not so common ground. But your 4 points that you outlined in your rebuttal, you say your testimony did not diminish the value of reliability to Dominion ratepayers or ignore NERC reliability standards. You say Dominion is not an electrical island. You say NERC reliability standards recognize that the perfect balancing interchange with neighboring BAs is neither possible, expected, nor necessary. And that's item 2, I think, of yours. I'm going to question you about that just a little bit. And neighboring balancing areas are an asset, not a liability. Does that kind of all in agreement with where you were on your rebuttal?
That's a good summary. I probably should have stuck to something that short.
Well, I'm not known for being succinct, but I'll try to be today. In the opening part of your rebuttal, you made a comment I want to ask you about first. Are you familiar with, and this isn't in your statement, are you familiar with the term gold-plated? When we use the word in the utility industry, gold-plated.
Yes, I do.
You say early on in your rebuttal summary testimony, there's often a trade-off between additional reliability, economic efficiency, which must be appropriately balanced. Over-stringent reserve requirements lead to unnecessary operating costs with only marginal or no benefits to overall reliability. And I'm not trying to put words in your mouth, but are you saying this goal? Are you saying that reserves to a certain level are gold plating?
Yes, potentially. You can over procure reserves at a high cost and not significantly or increase reliability at all.
And you're advocating for sharing, as you said, with neighboring states like VACAR and neighboring balancing authorities, I should say.
Yeah, I mean, contingency reserves and the operating reserves that we're talking about here are different, but it's a good example. The contingency reserve sharing group, Dominion Energy, does not carry spinning reserves for the loss of the largest generator. Right? They've determined that already to be too expensive for the ratepayer. And so to make sure they're still compliant, they've worked with neighboring utilities to share that requirement and reduce costs to the ratepayer. And because they recognize that the chances of multiple generators going down at the exact same time across multiple service territories is very low. So I'd advocate for a similar mindset be applied here. Now, it doesn't necessarily have to be done in a reserve sharing group, but a similar mindset of sharing capability across the system.
And you're saying that this can be done without our reliability being threatened?
Yes, I think so.
Next, I want to kind of ask you the question in the reverse way, and I don't know if, do you have Dr. Tanner's testimony up there?
Do you mind if I add one thing about the reliability?
Certainly.
So there are other utilities around the world, around the country that have significantly more solar and other variable renewables added to their system. I follow grid outages events, blackout events pretty regularly, and there has not been one to my knowledge that's been caused by solar variability or uncertainty. So there's been blackouts, and it is a risk on the system. I do not know of one that's happened due to uncertainty in the solar resource or variability in the solar resource.
But at the same token, you realize that NERC, North American Reliability Council, has in place all of these standards, and they're extensive to prevent that from happening, not only to South Carolinians, but to everybody in the Eastern Interconnect, the Western Interconnect, ERCOT, and all of the lower 48.
Yes, absolutely.
I want to refer you, if you do have Dr. Tanner's testimony, I want to refer you to his rebuttal testimony on page 11.
Okay.
Are you there?
I'm there.
I'm really referring to the bottom down there, the bottom half of that page, I guess. But basically, Dr. Tanner expresses that Dominion does not need any new resources at the moment, and implies that you advocate for adding facilities solely to integrate renewable power. And I had that exchange with the previous panel about the focus of Act 62, be it avoided cost or renewables, or if in this phase we're talking about just renewable power only, that arm of Act 62. But if no new resources are needed, why should the company add facilities to solely only benefit renewables?
Yeah, let me clarify what I believe Dr. Tanner was trying to say, and as well as my rebuttal testimony tried to say. So in Dr. Tanner's report, they looked at a few ways to manage the solar uncertainty. One was using their own reserves, and they said they also looked at adding new resources like a combustion turbine or a battery storage to provide those reserves. And
I think that's at the point where you referred to Hawaii.
Yep, and they said that those were not cost effective when evaluated solely to provide reserves. And what I took note of is when you look at specifically around battery storage, if you look at that only as a reserve asset, I agree with him right now, that might not be economic. I believe over a 13-year, 15-year study that this looked at, potentially it very well could be. But currently, in today's prices for South Carolina, as a reserve asset only, I would agree with him. But there's a lot of services that batteries can provide that they didn't look at. And so when you look at any asset on the system, it doesn't just provide one purpose, right? A gas turbine doesn't just provide capacity, it provides capacity and energy, and same with any other asset on the system. And so what I was referring to is looking at battery through the lens of only providing one type of reserves is limited, and there's other values that could make it economic for the ratepayer.
I'd certainly, in other words, you agree with him now under the current technology. Should that change, in other words, the improvements in technology with battery storage, then that would have to be factored in.
Sorry, no, I don't agree that batteries should only be looked at through a lens of as a reserve asset. There's a lot of other functionality that you could use multiple value streams. If it was connected to a solar plant, it can provide not only these reserves, but it could provide firm capacity.
Right.
It could provide energy arbitrage from low price hours to high price. It could defer potentially transmission distribution. So I would advocate if you're going to look at it as another mitigation, make sure to look at it for all the service it can provide, not just an individual one in isolation.
Certainly. Well, I appreciate your answer, appreciate you clarifying that, and that's all I have, Mr. Chairman.
Thank you, Commissioner Whitfield. I think we can safely say that you're still not known for being succinct. Any other questions, commissioners? Okay, Ms. Bowen, any redirect?
Do we have a pointer available? Should I know where that is? No, that's okay. Okay, Mr. Stenslick, Commissioner Belser asked you several questions about forecasting and 4 hours versus 2 hours. Okay. And what I want to ask you is if you could walk through, and feel free to use a chart if that's helpful, I think it might be. If you could walk through on that chart how a 2-hour forecast or a look ahead, how that would work, looking again at this chart and how the variability of the solar on this particular day they've presented, and then compare that with what Dominion has proposed to do in operations, which I understand is a little bit different from what they've actually modeled in the Navigant study. Hopefully that wasn't too much, but I think that could be helpful.
Thank you. So going back to the question about forecasts and forecast accuracies, from this example, you can see solar ramps up in the early morning hours as the sun rises, and then starts a gradual decline across the extent of the day. And so we see over 6 hours, it's tough to see the legend there, but over 6-7 hours, the solar is dropping out. So slow drop in the solar resource. And the green line was predicting a perfectly sunny day and no drop in the solar. But when you get through the first couple hours, or maybe the first hour, and you start to recognize that that forecast was inaccurate and the solar is dropping, you would never stick to the original forecast as it projected a perfectly sunny day. You're going to take in that new information and the reality of that day's operations, right? And you're going to take in that new information, continually update your forecast, and the more you update that forecast, the more you shorten that time window, the more accurate it's going to get. So while this looks like the late afternoon forecast was completely off, in reality, as you progress through the day, by noon, you know that forecast was off, and you've been able to assimilate that information and make changes to make sure that you can correctly account for that. So the forecasts are going to be regularly updated. You know, going back to what was done in the Dr. Tanner's analysis was just looked at the solar resource for a hypothetical year of data over 8,760 hours, and then compared that with a simulated forecast of that period and looked at each individual forecast error. And so it didn't take into account this ability to have the rolling forecast. And it just said, if you were off in the original forecast, you were off for every single one of these hours. And again, going back to the reserve requirements are driven by these outlier events. And so I would say that outlier event wouldn't actually occur in practice because you would update your processes as you go throughout the day.
So it didn't take into account that feedback loop. Is that a way to talk about it?
Correct.
Okay. And then the follow-up question, so, and you've just described the Navigant study. I know you were primarily focused on that Navigant study, but based on your understanding of the 40% or 35 or 40% of a forecast, how Dominion is actually proposing to operate going forward, can you explain how that differs as well on this chart?
Yeah, so if we were to go with the proposed 35 or 40% rule that's on the table today, if you look at the beginning half of that day, a 40% of 300 would be high, right? It'd be over 100 megawatts. But as you progress through the day and the solar drops off, you wouldn't use that original estimate of 300 megawatts of solar to establish the reserves. You would use what's actually on the system at that time. And so when the solar drops to 100 megawatts, the reserve requirement should also drop. Even if you were to assume the 35 to 40% rule is appropriate, the reserve requirement should drop as the solar drops. And that goes back to my comments about it's really important to have these reserves dynamically adjust to the realities that are on the grid and the solar resource.
Thank you. That's all I have.
Thank you, Ms. Bowen. Anything else for this witness? Yes, sir.
That's on, excellent. Mr. Tindlick, let me see if I understand what you're saying here. Your testimony. And if I may, it needs to be narrowly limited to the question that I asked. Yes, your testimony concerns this chart and the questions you ask about about how a system operator should respond. And what you're saying is that as you get into the middle of the day and you see the solar dropping, the system operator should assume that the system operator should be able to reduce reserves. Is that correct?
Yes.
All right, sir. How do you know that the solar is not going to bounce back up? You'll end up in an oversupply situation.
Yes, that could happen. And what I would say to that is the reserves that we're discussing here are up reserves. So as the solar drops out, can you ramp something else up quick enough? If the solar bounces back up unexpectedly, and even if it does so very quickly, you have two options. One is to back down all of the thermal generators that are on the system, so you can back it down to lower loading levels. If you exhaust all of that down reserve or the ability for those units to back down, you could, if you need to, curtail the solar. So that is an option that's available. And while it would incur a cost to the ratepayer, it's an option and reliability would not be threatened.
I think if you curtail solar, that would be a cost specifically to the solar developer also, wouldn't it?
I apologize. I don't know who bears the cost for curtailment.
And you understand that if a combined cycle unit is not already heated up, it takes 4 to 6 hours to get any capacity out of it. You understand that, don't you?
There's two things I'd like to say about that. We did an information request.
Make sure you're in front of that microphone.
Yeah, sorry. A few things I'd like to say about that. We submitted an information request. I don't have it handy to confirm the start times, and we were. And
I understand he said that you could bring a system up, combined cycle unit up in that time frame. I want to test that. I don't believe that's true.
As the solar is rebounding, you'd actually want to bring generators down or potentially offline.
Correct. But you understand that it takes, from a cold state, it takes 4 to 6 hours to bring any capacity up on a combined cycle unit on Dominion's system, correct?
Three points to that. We did submit an information request asking about the start times of the combined cycles, and we referred to between 2 and 4 hours, I believe. The second piece is there are changes that you can make to the combined cycles to make them more flexible, and a lot of utilities are pursuing that. So there's ability to allow them to ramp down to lower loading levels and potentially cycle faster. And then the third piece I would add to that, there's a start time. When we look at combined cycles, it's not an individual unit. It's typically comprised of at least 2 gas turbines or potentially 3. I don't know the exact configuration of the Dominion plants, but if there's 2 gas turbines online and the steam turbine, that steam turbine is what takes time to get up and running. And so it can be operated oftentimes, again, don't know the specifics of this plant, but generally it can be operated with 1 gas turbine online and 1 steam turbine. And then when you go to turn on that second gas turbine or the third gas turbine, that can start very quickly.
All right. Let's look at this, this day, which is the other piece of the slide. So she asked him about what happened during the day. Is this part of the evidence?
I'm going to sustain that.
All right. Thank you, Your Honor. No further questions.
Thank you. Okay. All right. Mr. Stenslick, thank you for your testimony. You may step down.
Thank you for your time.
Okay, I know we've got to do some changing up some technology stuff. With the next, you may step now.
Mr. Mr. Chairman, may this witness also be excused?
Yes.
Thank you.
Okay, we're going to take a short break while we get our next witnesses ready.
To begin recording your conference, press 1. To cancel, please stand by while your recording connection is established. To cancel the recording, press star 2.
Please repeat all that. I'm just kidding.
This conference is being recorded.
Okay, Mr. Nelson, if you will call your witness, then I think I'm going to swear him in, and then we'll proceed from there.
Thank you, Mr. Chairman. ORS calls its first witness, Mr. Brian Orey.
Okay, Mr. Orey, welcome. I think we need
Thank
to.
you very much.
And before we do this, I want to remind everyone, there's going to be a little bit of a delay, so when we're asking questions and going back and forth for Ms. Tackett's sanity, delay a little bit so we can, we'll have nobody talking over the top of each other. So, Mr. Orey, if you will please raise your right hand. You solemnly affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth.
I do.
Thank you. Okay, Mr. Nelson.
Thank you, Mr. Chairman. Mr. Orey, could you please state your full name, occupation, and business address for the commission?
Brian Horry. I'm a senior partner at Energy and Environmental Economics. We are located at 44 Montgomery Street, Suite 1600, San Francisco, California, 94104.
Thank you. Could you please tell us what the purpose of your testimony is here today?
Yes, I have been retained by ORS to assist in reviewing the avoided cost calculations, PPA contracts, commitment to sell forms, and other terms and conditions proposed by Dominion Energy South Carolina.
Mr. Orey, are you the same Brian Orey who pre-filed 51 pages of direct testimony with this commission on September 23rd, 2019?
Yes, I am.
Do you have any changes, edits, or corrections to your pre-filed direct testimony?
Yes, I do have a correction. Going to page 40, I'd like to strike the paragraph that begins on line 20 and continues on through page 41, line 6. The struck paragraph was based on DESC's description of resources in the base case and change case tabs of their avoided cost work papers. After further review, I found that those descriptions were inaccurate and that DESC did apply market purchases in the change case as well as the base case. This correction, however, does not change my recommended values for avoided costs.
Thank you, Mr. Orey. And besides that correction that you just gave us, do you have any other changes to your pre-filed direct testimony?
No, I do not.
Thank you. Mr. Chairman, ORS would ask that the pre-filed direct testimony of Mr. Brian Orey, as amended from the stand, be read into the record as if given orally from the stand.
Mr. Orey's pre-filed direct testimony as amended will be entered into the record as though given orally from the stand.
Mr. Horry, did you also cause to be filed a 7-page exhibit marked as BKH-1?
Yes, I did.
Have any changes, edits, or corrections to that exhibit?
No, I do not.
Mr. Chairman, ORS would ask that the exhibit filed with Mr. Orey's direct testimony marked as BKH-1 be admitted into the record as the next exhibit.
Mr. Orey's exhibit BKH-1 will be entered into the record as hearing exhibit number 13.
Thank you, Mr. Chairman. Mr. Horry, do you also prepare or cause to be prepared 15 pages of surrebuttal testimony, which was filed with this commission on October the 11th of this year?
Yes, I did.
Do you have any changes, edits, or corrections to your pre-filed surrebuttal testimony?
No, I do not.
Thank you. Mr. Chairman, ORS would ask that the pre-filed surrebuttal testimony of Mr. Orey be read into the record as if given orally from the stand.
Mr. Orey's pre-filed surrebuttal testimony will be entered into the record as though given orally from the stand.
Thank you. Mr. Horry, I'm going back a step because I think we probably have a few commissioners that are here that haven't heard you testify before. Could you briefly summarize your education, your experiences detailed in your CV?
Yes, so I'm one of the founding partners of Energy and Environmental Economics. I've been working in rates and avoided costs for over 30 years, since graduating from Stanford University with a master's degree back in 1987. Here at E3, I'm the lead in the practice areas of resource planning, energy efficiency and demand response, cost of service and rate design, and act as a lead in the quantitative methods for the firm. I also work in the energy and climate policy, distributed energy resources, and regulatory support practice areas. I have testified and prepared expert testimony for use in regulatory proceedings in California, Texas, Vermont, British Columbia, and Ontario, Canada, and I have testified twice previously before this commission in the fuel cost dockets for SCANA at the time in the past 2 cases.
Thank you, Mr. Horry. Did you prepare a summary of your direct and your surrebuttal testimonies?
Yes, I did.
Would you please present them to the commission now?
Thank you. So at a high level, my testimony has the following findings and recommendations. For the value of solar integration, or VIC, I find that the Navigant VIC study is overly risk-averse in determining the need for additional operating reserves to account for the intermittency of solar generation. The Navigant study is overly risk-averse by focusing on just solar generation and not considering the totality of risk that involves all generation, transmission, and customer demand deviations. The Navigant study also overstated operating reserve need by holding reserve levels constant over all hours when solar is operational. While I was not able to correct for the second problem, I was able to use Navigant data to estimate VIC costs using a more reasonable level of additional operating reserves. By using my more reasonable level of additional operating reserves, the VIC drops from $4.14 per megawatt hour to $2.29 per megawatt hour, which is comparable to the solar integration cost proposed by Duke Energy Progress in docket number 2019-186-E. I also propose that DESC should be required to conduct a new VIC study and involve the solar community in that process to allow more efficient interchange of ideas than is likely to occur in a hearing process such as this. Avoided energy costs. Dominion proposes the VIC be applied to some existing solar contracts and that a different calculation method be used to derive integration costs for future solar projects. For future solar, Dominion estimated integration costs as part of its avoided energy cost analysis via the increase in operating reserves for the change case with solar resources. In my direct testimony, I raised concerns over the way that Dominion quantified the need for additional operating reserves due to solar. After seeing the DESC amended direct testimony, I developed even stronger concerns, given the large change in results relative to the Dominion direct testimony and the large magnitude of revised integration costs in the amended direct testimony. I therefore recommend in my surrebuttal testimony that avoided costs for solar QFs and solar with storage should start with Dominion's avoided energy costs for solar resources that exclude any additional operating reserves. My recommended VIC should then be subtracted from these avoided energy costs to arrive at avoided energy costs for solar that reflect a reasonable estimate of integration costs for solar. Avoided capacity costs. I find that Dominion has underestimated the avoided cost of capacity for all resources through the use of 4 incorrect assumptions. 1, an incorrect reserve margin. 2, excessive and inconsistent use of low-cost capacity resources. 3, an overly long CT life. And 4, a mismatch between the avoided cost resource change and the assumed size of the CT unit. The first 2 assumptions lower the avoided capacity cost by pushing out the date when a CT is needed and assuming low cost to provide capacity in the early years. Dominion also assumes a 60-year life of a CT, which is far beyond the commonly used 20-year life. By using an excessively long CT life, the fixed costs of the CT are spread over far more years, and the annual cost of the CT that feeds into the avoided capacity calculation is underestimated. Regarding the mismatch problem, to calculate avoided capacity costs, Dominion models the addition of 100 megawatts of free generation, but assumes that the size of a CT unit is only 93 megawatts. I show that using other mismatched amounts of added generation and CT sizes could easily alter the avoided capacity cost by a factor of 15. Using free generation and CT sizes that are the same would eliminate this consistency problem and increase the avoided capacity cost by 7%. Solar capacity value. Dominion asserts that solar can provide no capacity value based on overly simplistic and deterministic analyses. I disagree and point out that Dominion's own ELCC analysis shows that current solar provides capacity value equal to 24% of nameplate capacity. The Dominion ELCC analysis further shows that near-term future solar would provide capacity value equal to 11.8% of nameplate capacity. While Dominion may not agree with the ELCC method, it is the industry standard for the evaluation of intermittent resources and properly reflects that there is a risk of capacity need over the entirety of the year and not just in winter mornings or evenings. Sir rebuttal. My Sir rebuttal testimony addresses Dominion's amended direct testimony and rejects Dominion's proposed avoided energy rates as I described above. My Sir rebuttal testimony also shows how Dominion continues to overstate the impact of solar outages on system reliability and shows that my recommended changes to DESC's estimation of avoided capacity costs are reasonable. I made several recommendations for changes to form contract PPAs and notice of commitment to sell forms. However, as Dominion addressed my concerns and modifications presented in its rebuttal testimony, I now find those documents to be reasonable. Finally, my Sir rebuttal testimony presents my recommended values for rate PR1 avoided energy rates for solar QS, rate PR standard offer avoided energy rates for solar QS, 10-year levelized value of DER, and current period value of DER. That completes my summary.
Thank you, Mr. Ori. Mr. Chairman, Mr. Ori is available for questions from opposing counsel or the commission.
Thank you. Any cross?
No cross.
Thank you. Any other cross?
Good afternoon, Mr. Horry. I'm Ben Snowden with the Solar Business Alliance. Can you see me okay?
I can, Mr. Snowden.
Okay, thank you. It's nice to see you again. I'd like to start by talking about your review of Dominion's integration charges. So you've testified that the calculation of integration costs that was presented in the Navigant study is not reasonable. Is that right?
That's correct.
Okay. And why is that?
Well, one of the issues is when you look at how the Navigant study was done compared to how the Estroppi study was done in the Duke proceeding that's going on simultaneous to this, you'll see that Navigant is only looking at kind of the variation in solar. And because of that, I believe that they're doing an insufficient sort of review of what the real risk is from solar drops, because you need to not only consider how the solar generation may drop, but you need to look at how that interacts with the rest of the system. For example, if that solar drops when you don't have high customer demand, or at times when you don't have generation outages, there's really no impact from that solar drop. It's very easy to accommodate that. But the Navigant study, by looking only at the solar drops and failing to adequately consider what's happening on the customer demand side, as well as looking at what's going on with other generation, I feel is doing a sort of an inadequate evaluation of the risk. Now, I understand that from past experience that the Commission likes to have sort of alternate values available to it. So for that purpose, I looked at, well, what changes could I make to their study to bring the results into what I consider to be a more reasonable range. And I saw that by reducing the amount of additional operating reserves that Navigant said they needed to carry, by assuming a little more risk on the solar output side, I could drop that integration charge from over $4 to the $2 per megawatt hour range.
Okay, thank you. And you testify in your rebuttal that Dominion is overly conservative in setting operating reserve requirements for solar generation in their studies?
Yes, sir.
Mr. Chairman, Dominion Energy objects to this line of questioning. This is friendly cross that is tantamount to another direct examination. If Mr. Snowden has points to which he differs with Mr. Horry's analysis, we would ask that he would move on to those points.
And I can assure the Commission I'm not simply trying to get Mr. Horry to repeat his testimony. That's the point to which I'm getting.
I mean, that's what he just did.
Well, I do like to lay a predicate for my next question. That's okay.
That's 3 questions.
Address up here.
Sorry. My apologies.
Okay, let's go ahead and make the point.
Okay, sure. Okay, so Mr. Horry, you testify in your rebuttal that there's no economic balancing of risks and costs in establishing reserve requirements. Is that right?
That is correct.
Okay. Now, you would assume, wouldn't you, that when Dominion actually operates its system, it does that balancing between risks and costs? Wouldn't you assume that?
Well, that's an interesting question because normally I would assume that Dominion would be doing that balancing of costs and risks because you would have the pressure of rate levels and basically the pressure from Dominion's customers that they should sort of insist on that cost reduction or cost control. In this case, though, with the integration charge, since it's being passed on not to Dominion's customers but to solar developers, I feel like there's a little sort of there's a different sort of dynamic there, and there may not be the same sort of pressure to reduce those costs as might exist if those costs were passed on to consumers.
But as a responsible system operator, Dominion has an obligation not to impose unreasonable costs on ratepayers. Is that right?
Yes, I would agree with that.
Okay. And what we're talking about here in the Navigant study is a modeling of sort of Dominion's expectations about reserve requirements. Is that right?
I mean, it's certainly a modeling of what I guess what their forecast is, their additional cost for integration. So I would agree with that.
Okay. So as I understand it, correct me if I'm wrong here, as I understand your testimony, you are not critiquing Dominion's sort of current operations of its system. What you're saying is that the model does not reflect what they would necessarily do in reality as a responsible system operator.
So to clarify, I'm definitely critiquing the study. I'm not, in my testimony, taking a position on their actual operating practices.
Okay. So the impact of the company's choice to be highly risk-averse here is to increase operational costs that it would propose to pass on to solar projects?
The assumptions they made here are certainly increasing the estimated costs that they're going to be passing on to the solar developers. Those estimated costs may actually be very different from actual costs, but I'm just focused on the estimated costs coming out of the study.
Okay, so if, I guess then maybe I've characterized this correctly, would you agree that if Dominion did actually operate its system in the way that it is modeling that it would, that if it did that, then it would not be acting responsibly in terms of balancing costs and risks?
In that case, I think Dominion would be incurring higher costs than would be necessary to balance the risks from solar.
Thank you. And Dr. Ori, it's your recommendation that any method for developing integration charges should be developed with input from stakeholders, including the solar industry, isn't it?
Yes, that's correct.
And why is that?
Part of that is because, this is a charge.
Ori, let me,
Mr. Chairman, I fail to see how this questioning is elucidating any differences between the SBA and the ORS. Both of these parties are advocating that solar developers should not have to pay the VIC, and this is essentially friendly cross tantamount to direct.
I need for you to get everybody to get to a microphone. I know everybody's got a point to make. Yeah, we got a line. Get in line.
If I may start. Dr. Horry, Mr. Horry testified that he would recommend a stakeholder process. This does not pertain to imposition of the VIC. He recommended a stakeholder process. He made the recommendation. I'm trying to understand his reasons for that recommendation. I don't oppose it, but I'd like sort of further explanation, which is not in his testimony.
Mr. Chairman, on behalf of Johnson Development, we need to build the record here. And I'm unaware of any rule of civil procedure, any rule of civil procedure, any rule of this commission that prohibits this line of questioning. There is an ORS witness who has been critical of all aspects of all parties. They chose not to cross him, and now they're trying to limit Mr. Snowden's cross-exam. And for the record, we need to have a ruling to allow Mr. Snowden to proceed. Thank you, Mr. Chairman.
Mr. Chairman, this commission has routinely, throughout the years, prohibited friendly cross. This is friendly cross. They don't disagree on these matters, and this is a waste of the commission's time and resources to continue to allow it.
Mr. Chairman, if I could be heard, since this is my witness too, we don't fully agree with either side in this case, and I think that's very clear by the testimony that Mr. Horry's put up. This is open cross-examination in the state of South Carolina, and I see no reason why Mr. Snowden shouldn't be allowed to ask these questions. And if I could also add, we did not conspire together or anything. I have not seen these questions before. I didn't know that they were going to be asked.
Okay, I'm going to allow you to continue. We don't need to hear a reiteration of the testimony that's been done.
Avoid that.
Excuse me. I hope that all came out.
Mr. Horry, you offer some testimony about Dominion's seasonal allocation of capacity. Is that right?
Yes, I did.
And one of the critiques that you offer on seasonal allocation is that Dominion, in modeling, excuse me, in modeling what its capacity costs are, fail to recognize the outage risks that exist in non-winter months.
Yes, that's correct.
Okay. So would you agree that their approach here is the opposite of the approach they're taking when they model reserve requirements? So there they are being extra risk averse, and here they're being risk preferring, for lack of a better word?
I don't know if I would agree with that statement, just because they're just so different. You know, what they're doing on the operating reserve side versus how they're evaluating peak. I'm just not comfortable saying that that's, or agreeing with your assertion.
Okay. Well, you have testified that with regard to the reserve requirements, they're being very risk averse. Is that right?
That is correct.
Okay. And in this context, when considering the seasonal allocation, they are ignoring or undervaluing certain risks on their system.
Yes, I would agree with that.
Okay. And the impact of that choice in both cases is to effectively drive avoided costs rates down, or avoided cost calculations down.
Well, the result on the allocation side is to drive avoided costs for solar down. It doesn't actually change the total avoided costs for non-solar QS.
Understood. Thank you. And Mr. Orr, you also testify that Dr. Lynch conducted an ELCC calculation that would assign a 24% capacity value to solar. Is that right?
It would be a 24% capacity value for existing solar, but a smaller capacity value for future solar.
Understood. And Dr. Lynch testified in his rebuttal testimony that the use of, of ELCC and LOLE methodologies to calculate the capacity value of solar wouldn't be appropriate for Dominion because it's a winter peaking utility. Did you see that?
Yes, I saw that this time, and over the years, Dr. Lynch and I have continued to disagree on this point.
Okay. So you would not agree that ELCC and LOLE are appropriate methodologies for use with winter peaking utilities. Is that right?
Yeah, I would argue that LOLE and ELCC are the industry standard way to look at capacity value, whether you're a summer or a winter peaking utility.
So are you aware of winter peaking utilities that use ELCC or LOLE for assessing capacity value?
Well, certainly in the Duke proceeding that I'm also involved in, they do use the LOLEs to look at the seasonal allocation, and they do come up with positive summer allocation for, I can't remember if it's DEP or DEC, and a very small amount for the other utility. They claim 0. I show it's 1%, and they basically agree that they're the same.
Okay, but Duke is, would you characterize Duke as a winter peaking utility, at least according to them?
Yes, I would.
Okay. Would you characterize Dr. Lynch's approach to, or his use of the convolution formula on this issue as industry standard, as he referred to it?
Well, the problem I have is, he does a convolution calculation, which is fine, but that's not the way he actually evaluates capacity. When he's evaluating capacity, he's just looking at the winter peak and isn't doing his convolution formula for that determination. So that's where I really have the problem with the Dominion approach and it being too simplistic and not probabilistic.
Okay. Are you aware of any other utilities that use the same approach that Dr. Lynch uses to calculate capacity values?
I'm thinking back perhaps 30 years ago. There may have been some, but I know there was a recent study done by, I can't recall if it was a PGM or a NARUC or a NERC subcommittee that looked at these techniques, and the vast majority were using LOLE techniques now.
Okay, so you would agree his approach is probably not industry standard in 2019?
Yes, I would agree with that.
Mr. Roy, I'd like to turn to your curriculum vitae. It is very impressive. And this is where you list your areas of expertise and experience. Is that right?
Yes, it is.
Okay. And I look at this and I say you have a lot of experience in a lot of topic areas that are related to utility economics. Is that right, or fair to say?
Yes.
Okay, and you've published a lot of papers and you've given a lot of testimony in a lot of proceedings, right?
Yes.
Okay. And your CV lists your experience in the areas of resource planning, energy efficiency, demand response, distributed resources, cost of service and rate design, transmission planning and pricing, and energy and climate policy. Is that right?
That's correct.
Okay. And you have degrees in civil engineering and environmental planning. Is that right?
Yes.
Okay. And you've been a consultant with, well, okay. But you're not trained as a lawyer, correct?
That's correct.
Okay. And you were asked by ORS to review the commercial terms of the form PPAs that were proposed by Dominion, weren't you?
Hang on, Mr. Kissendanner.
I still fail to see where this is cross-examination. We'd be happy to stipulate Dr. Horry's curriculum vitae into the record.
I've finished my discussion of that topic. We'll see where it's going. So, Mr. Ori, to repeat my question, you were asked by ORS to review the commercial terms of the form PPAs proposed by Dominion, weren't you?
Yes.
Okay. And your conclusion was that with some exceptions, they were generally commercially reasonable and conformed to industry standards. Is that right?
Yes, that's correct.
Okay. So as we've discussed, Mr. Ori, your resume is very impressive, but one thing I do not see listed in your CV is any experience related to the negotiation of power purchase agreements or the financing of solar projects. Is that right?
That's correct. So to do the form review, I actually utilized other resources here at E3. You know, we have here in San Francisco over 50 professional staff, several of whom are sort of more expert in those areas, so I consulted with them in reviewing those materials.
Okay. So, and those individuals are not available here for cross-examination, right?
That's correct.
Okay. Have you ever personally negotiated a power purchase agreement?
I've been involved in sort of developing, let's see, back in the days of utility deregulation in California, we actually had a, I don't know if you'd call it a company or a website called Gen Energy. We actually did power purchase agreements between sort of utilities, third parties, and those looking to sort of take advantage of direct access in the electricity markets. So I was heavily involved in contract terms and issues related to PPAs back then.
Okay. I'm sorry, how long ago was that?
I think that was around 2000, I believe.
Okay. And just to be
maybe
clear,
98, 2000.
Okay. And just to be clear, that was in a deregulated market. Is that right?
It was because of the deregulated market that you now had the opportunity for all of these sort of sales and purchase opportunities.
Okay. And would you agree that the mechanics of a power purchase agreement in a deregulated market between market players would be very different than the mechanics of a PPA between a monopoly utility and an independent power producer in a regulated market like South Carolina?
I don't know if I'd say very different, but there certainly could be differences.
Have you ever been involved in the negotiation of a PPA in a regulated market?
You know, I have helped review terms and conditions, but I haven't been sort of intimately involved in the negotiation.
I'd like to turn to the liquidated damages provisions of the proposed Dominion contracts. Mr. Ori, are you aware that Dominion originally proposed in its Form PPA to impose liquidated damages of $55,000 per megawatt on a project that was late in achieving commercial operation?
That sounds familiar.
And are you aware that in its revised filing, Dominion reduced that amount to $41,000 per megawatt?
Accept that, subject to check.
So, assuming that's correct, $41,000 a megawatt, a 50-megawatt project that was late in achieving commercial operation would have to pay liquidated damages of about $2 million. Is that right?
That sounds about right.
Mr. Ori, I understand that you're not a lawyer, but are you familiar with the legal requirements for liquidated damages to be enforceable under South Carolina law?
No, I am not.
So you're not aware that in South Carolina, as in many places, one factor courts look at is whether liquidated damages bear some reasonable relationship to the harm that would actually be suffered in the event of a breach. Are you aware of that?
I'm aware that that's a common condition. I'm just not aware of the South Carolina particulars. Understood.
Mr. Orr, have you seen Mr. Cassis's testimony that $2 million is a good approximation of the economic harm that Dominion would face if a 50 megawatt solar project was late coming online?
I did review that, but didn't really focus on that.
Okay, so do you understand Mr. Cassis's explanation of how he arrived at the $41,000 per megawatt number?
Generally.
Okay, could you explain it to me, if you can recall?
You know, I can't recall offhand. If you want me to go back through the testimony, I could, but I'm not sure what that accomplishes.
Oh, understood.
Again, the liquidated damages area wasn't an area that I chose to sort of focus my attentions on, given the short time frame involved in the review of this case.
Understood. Yes, we were on. I sympathize with the time pressure. Okay. So just to be clear, this liquidated damages term was not one that you focused on, or that your associates or colleagues focused on in their review of the contracts. Is that right?
That's right.
Okay. Did you or your associates focus the review on the sorry, withdraw that question. I've got no further questions. Thank you, Mr. Ori.
Thank you.
Commissioners. Commissioner Belser.
Good afternoon, Mr. Ori.
Good afternoon.
I just have just a few questions. Mr. Bell for Dominion, in his rebuttal, stated that operating reserves, or that Dominion has data that clearly shows that drops of 35% of installed photovoltaic solar megawatts occur with significant frequency over a 1 hour time frame. I believe you've taken exception to that 35%. Does reducing reserves in Dominion's model to 18% adequately address the risk of drops?
You know, I'm glad you asked that question, because I know a lot of hearing time has been spent talking about that 35% drop number. And, you know, the reality is, when I look at their amended direct testimony, they have such a large integration charge in there, you know, far larger than we're seeing from the other South Carolina utilities, far larger than we've seen from other solar integration cost studies. But it just makes me question whether the fundamental methodology that they're using is even appropriate. And so because of that, I don't believe that even using an 18% number in their analysis would, you know, necessarily provide a reasonable result.
Can you expand on that when you say fundamental, and I don't recall the word you just used, fundamental or difference in their methodology? Explain what you're referring to there, please, or expand on that.
Sure. So, you know, if you look at what's been done to quantify solar integration costs in South Carolina now, you basically have three different methods. You have the avoided energy cost analysis method that you know, Dominion uses, and that's where the 35% number is used. You have the Navigant study that's used to do a VIC calculation that's, you know, it's kind of trying to get to the same thing, but it's calculated in a completely different way. And then you have the Astrompi study that's been done for Duke Energy Progress in Carolinas that does, you know, more advanced sort of look at what those integration studies could be. So you have these three studies, and you look at what's been done with that 35% number, that is nowhere near the same level of rigor and analysis as is done in the other two studies. And given the large magnitude of the number it's coming up with, you know, that just gives me great pause about accepting sort of that method, because it's the most simplistic method, yet it's giving the biggest value.
And you're recommending the 18%? Is that correct?
No, I'm actually recommending that their avoided energy cost analysis with the additional operating reserves just be disregarded. And instead, what should be done is take the estimate of avoided energy cost with no additional reserves for solar, because that's basically what Dominion's been doing for years. So there's sort of a nice precedent, and there's a history for doing those kind of calculations. So start with that, and then subtract out the integration cost that I recommend based on the Navigant study. So in that way, we don't have to rely on the faulty 35% analysis, but we can still factor in an additional cost for solar integration by using sort of the amended Navigant results, or my revised Navigant study results.
Would your recommendation adversely affect reliability on the system?
I don't believe so, and I don't believe that Dominion can state otherwise, because they haven't really looked at system reliability in either the 35% analysis or the Navigant study. All they've done is looked at what happens with solar. But as I stated earlier, system reliability, it's basically a 3 or 4 legged chair. There's the generation, thermal generation, regular generation, and its outage risk. There's customer demand and its risk of spiking up. And then there's the risk of not being able to import over transmission lines. So those are the 3 sort of standard legs of the stool that you need to look at when thinking about risk, because it's the combined sort of risk of all of those elements that contribute to reliability. Now, a solar, in a way, that's sort of peeling solar out from the generation leg and creating its own 4th leg of generation risk. But I contend you can't just look at solar in isolation. You have to look at it in combination with all these other factors, and that's what Dominion hasn't done in their analyses.
Thank you very much. Appreciate your attention to my questions. That's all I have, Mr. Chairman.
Thank you. Commissioner Howard.
Tori, welcome. Tori, Dr. Lynch, in a rebuttal testimony, argues that system dispatchers cannot deploy solar capacity during winter peaking times, and therefore he does not provide capacity when needed. Why should a capacity value be assigned to solar when solar cannot be deployed during the winter peaks?
Yeah, that's a great question. So that really sort of isolates sort of this whole issue of what's happening with the rest of the system. Well, Dominion is a winter peaking utility. The summer peaks and the winter peaks are pretty close. So if you can sort of imagine a situation where you have generation outages, substantial generation outages during the summer, you could easily have a capacity problem in the summer. So yes, maybe your risk of having an outage problem is higher in the winter, but that doesn't mean there's no risk of an outage and therefore no value from having added solar capacity in the summer. Sure, it won't be able to handle that specific winter problem that he talks about, but there are all these other days where there is some risk of having an outage if, customer demands are high, if you have generation outages, and those don't exist solely in the winter.
Also, will the addition of additional solar resources reduce companies' capacity needs regardless of when the company is peaking?
Let's see, so the addition of solar will certainly sort of alter the value of solar, because the more you add, the less valuable the next amount of solar is going to become. And we even see that with Dr. Lynch's ELCC results, where there's a 24% roughly value of current solar, but the next amount of solar, it's only getting about 11 or 12% capacity value, and so you would expect to see a continued reduction in the value of solar as more and more gets installed on the system.
Thank you very much. Appreciate it. Mr. Chairman, thank you.
Thank you. Commissioners, any other questions? Any redirect? Thank you. Mr. Horry, thank you for joining us. We appreciate your testimony, and you may step down wherever you are.
And I guess, could I,
Thank you very much.
Or hang up.
I ask that he be excused?
And you may be excused.
Thank you.
Okay, Mr. Nelson. Ms. Pittman.
Thank you, Mr. Chairman. ORS calls its next witness, Mr. Robert Lawyer, to the stand.
To end the conference recording, press 1. To cancel, press. This conference is no longer being recorded.
Thank you very much.
Do you solemnly affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth?
Mr. Lawyer, please state your full name, your occupation, and by whom you are employed.
My name is Robert A. Lawyer. I'm employed as a senior regulatory manager with the Office of Regulatory Staff at 1401 Main Street.
Thank you. Are you the same Robert Lawyer who filed or caused to be filed 8 pages of direct testimony on September 23rd?
Yes.
Do you have any edits or corrections to that testimony?
I do not.
So if I asked you the questions in your testimony here today, your answers would be the same?
Yes.
Thank you. Mr. Chairman, I would ask that Mr. Lawyer's pre-filed direct testimony be read into the record as if given orally from the stand.
Mr. Lawyer's pre-filed direct testimony will be entered into the record as though given orally from the stand.
Thank you. And Mr. Lawyer, did you also file or cause to be filed 3 pages of surrebuttal testimony on October 11th?
I did.
Do you have any changes or corrections to that testimony?
I do not.
So if I asked you those same questions here today, your answers would be the same?
Yes.
And Mr. Chairman, I would ask that Mr. Lawyer's pre-filed surrebuttal testimony be read into the record as if given orally from the stand.
Mr. Lawyer's pre-filed surrebuttal testimony will be entered into the record as though given orally from the stand.
Thank you. Mr. Lawyer, did you prepare a summary of your testimonies?
Yes.
Could you please present that to the Commission at this time?
Sure. Good afternoon, Mr. Chairman and members of the Commission. The purpose of my direct testimony is to set forth the results of ORS's examination of Dominion Energy South Carolina's compliance with certain sections of the South Carolina Energy Freedom Act, or Act 62. The company's filing included all of the items that were required in Section 58-41-20A that included a standard offer, avoided cost methodologies, form contract purchase power agreements, commitment to sell form, and any other terms and conditions necessary to implement this section of the Act. I assert that I assert that this Commission has the flexibility and discretion under Act 62 in determining how often to hold proceedings to update the company's avoided costs, such as more frequently than every 24 months. I highlight that customers are ultimately responsible for all avoided cost payments to qualifying facilities under purpose mandatory purchase obligation, and stress the importance that the methodologies employed by the company and the resulting avoided energy and capacity rates fully, fairly, and accurately account for costs avoided or incurred by the company in accordance with Act 62. This includes variable integration charges that can help limit subsidization of QFs by ratepayers. I affirm the company's proposal to implement a true-up of avoided energy and capacity, variable integration charges, and the value of distributed energy resources in their next annual fuel proceeding, which would be docket number 2020-2-E. I affirm that rate PR2 is no longer necessary and concur with the company it should be terminated. I also express concerns with certain language in the company's proposed
rate PR1, rate PR standard offer, and rate PR avoided cost methodology tariffs, and request clarifying additional language. ORS supports the recommendations put forth by witness Brian Ori and find them just and reasonable to the company's customers, consistent with PURPA and the FERC's implementing regulations and orders. They're non-discriminatory to QFs, qualifying facilities, and serve to reduce the risk placed on the using and consuming public. This concludes the summary of my direct testimony.
Do you have a summary of your rebuttal testimony as well?
I do.
Please present that to the Commission at this time.
My rebuttal testimony addresses issues raised in the rebuttal testimonies of company witnesses Alan Rooks and Daniel Cassis, and reflects ORS's discussions with the company related to certain proposed tariffs in this proceeding. Number one, regarding witness Rooks, I recommend the company add clarifying language to the rate PR avoided cost methodology tariff, section C, which was entitled Updates. Since I prepared this summary, as you heard witness Rooks this morning, they did agree to that recommendation. Number two, regarding witness Cassis, after further discussion with the company, ORS finds that the tariff language is sufficient as proposed. This concludes my summary of my rebuttal testimony.
Thank you. Mr. Chairman, Mr. Lawyer is available for cross-examination and questions from the Commission.
Thank you. Cross-examination.
No cross.
Thank you. Any other cross? Commissioners. Commissioner Hamilton.
Thank you, Mr. Chairman. Mr. Lawyer, how are you today, sir?
I'm doing well, thank you.
All right, I assume that I heard you say that you were familiar with Mr. Rooks' testimony.
Yes.
Let me read a statement and you tell me if this is accurate.
Is this his direct testimony, sir?
Yes. On page 2 of Mr. Rooks' rebuttal, excuse me, this is a rebuttal testimony.
Oh, okay. It's a different book.
Okay. On page 2.
Okay.
All right. He presumes that your reference to factors or analysis is not intended to require your references to, not intended to require the company to seek commission approval prior to updating the company's data inputs incorporated into the methodology. Is this correct?
That is correct, Commissioner. And we have clarified the clarifying language in the tariff we agreed upon.
Thank you very much.
You're welcome.
Chairman.
Thank you, sir. Commissioners, any other questions? If not, then Mr. Lawyer, thank you for your testimony, and you may step down. Okay. I think we have heard from everyone we're going to hear from. We thank everybody for being here, everybody's testimony, and everybody's participation. And there's nothing further. We are adjourned.